It will be listed tomorrow again. You give the memo.
Yes.
And then you show us this order. We'll pass the same
Yes,
order.
that order
So
is.
segregate this order. Keep it with you now for the day because it will be sent to the registry. It will not be the part of the record.
I am only giving the memo. Tomorrow I will.
All right. Yes. Call the next matter.
Item 1.
May please your lordship.
Yes.
The order of the Honorable Single Judge at Annexure 9 is the subject matter of challenge in this appeal, which was passed on 2/8/2021.
This is the Annexure 9 is the order.
My lord.
Annexure 9 is the
Annexure
order.
9, page 35. May I read the impugned order?
No, the relevant part only.
It starts from 35. Having heard and counsel for the parties and after going through the records, it appears that the petitioner was appointed as an additional teacher in Panchayat High School, Lakshmi Nagar, while resolution number 73 dated 21/12/1991 of the managing committee against the post of additional section teacher of class 10B, pursuant to which he joined on 3/1/1992 and subsequently acquired BD qualification as an in-service candidate during the year 1999-2000. The petitioner rendered service as an additional section teacher up to 23/8/2001. Subsequently, the school in question was taken over by the government with effect from 7/6/94 pursuant to the resolution dated 16/12/1994. There was no correspondence with the higher authorities to create additional section in
Mr.
the school.
Ratho, please come to the page 36.
Middle. That
Yes,
paragraph.
just on this long paragraph, the
Yes.
last few lines.
Yes.
In view of such position. Last few lines. Of the long para in this page 36.
In view of such position, since no prior permission was obtained.
Yes, in view of the position that no prior permission was obtained, so far as the petitioner's appointment is concerned, this court is not inclined to interfere with the order impugned. The prior permission.
Thereafter, more so
the petitioner is no more in employment with effect from 23/8/2001, and in the meantime, more than 20 years have passed.
Yes, this is the thing. How do you overcome this thing?
Because I was not allowed, as per the order of rejection of my approval under Annexure 8, I moved the law tribunal for approval, seeking a direction for quashing of the rejection order and for approval. And if at all I was not
there are two questions.
Yes. Prior
First of
permission.
all, there was no prior permission.
Prior permission. Second is not in employment from 23/8/2001.
One, and you filed the original application only in 2016.
2016 was the order of rejection. That is Annexure 8.
When we filed the original application?
In 2016, against the order of 2016.
No, just when you filed the original application, because the original application has come here as now it is a writ petition.
Original application I filed in 2016.
16.
Against the order of the authority.
Wait for some time. That in 2001, you are discontinued from the service, and your first legal action against the authority was taken in 2016. How do you explain this 15 years lapse?
But I was pursuing my grievances before the government.
That is well settled law. By giving representation and representation, you can avoid the latches.
Reasoned order has been passed under Annexure 8 by the government. A reasoned order was passed,
right.
And that order was challenged in 2016.
Where is the reasoned order?
That is the page 32.
All right, let us see.
Annexure 8, page 32. The Honorable High Court of Orissa, in their order dated 7/12/2015, in WPC number 21543 of 2015, have directed as follows. Considering the contentions raised by the
not related to you. This order is not related to you.
Yes, related to me. Your lordship say paragraph 1.
That means you had filed a earlier writ application.
Earlier writ
So all
application.
that you have to say, haven't you not filed a date chart?
Yes, my lord, I have filed it.
Then all that you have to say.
That rate application after 14 years.
That
Ah.
to dispose of representation, which
Yes.
was disposed of like that.
Your lordship, page 28.
Your lordship may refer to my date chart. Your lordship got it?
Where is the date chart? Ah.
I filed on 18/7/2023. Last date.
What happened to this, your OGC number 4129 of 1994?
That was disposed on 11/7/94.
Yes, what is the order?
That is serial number 10 of my date chart. This honorable court disposed of the writ petition OGC number 4129 of 1994 with the direction that the competent authority will consider the proposal and communicate his order to the management of the school and also to the petitioner within 3 months. As a compliance to the aforesaid order, though the erstwhile inspector of school Sambalpur moved the director secondary education Odisha, who having remained silent for years together, the appellant filed a petition OJC 18,379 of 1997.
97.
On 30th March 1998, this honorable court disposed of OJC number 18379 of 1997 with the direction to the director of secondary education Odisha to deal with the matter relating to approval of services of the appellant, if pending, within 4 months from the date of receipt of the said order.
Yes.
In obedience to the order of this honorable court dated 30th March 1998, the director moved the government, who is the authority competent to the matter of sanction of additional post. Since the government delayed consideration of the proposal of the director, the appellant filed OJC 8381 of 1998. After taken over of the aided high schools with effect from 7/6/94, the government created as many as 701 numbers of additional section teacher posts, which have been held by BED trained teachers as on 7/6/94 out of 869 numbers of approved teachers of the then aided schools. Since beyond 701 additional section teachers were directed to be removed by the government, by the order dated 24/4/2000, they filed cases before the Odisha Administrative Tribunal, filed OA number 1634C of 2000 and batch of cases. Apart from the above, 118 numbers of additional section teachers in whose favor recommendations for approval was pending at the level of the government, apprehending that they may be removed, filed cases before the OAT filed OA number 405C of 2000 and batch of cases. During pendency of the writ petition filed by the appellant, filed OJC number 8381 of 98, the appellant passed BD examination on 16/11/2000. The learned tribunal disposed of OA number 405C of 2000 and batch of cases filed by unapproved additional section teachers appointed prior to 18/12/1993 without having BD degree, with the direction to approve the appointment of the applicants, those who passed BD degree at the time of appointment with effect from 7/6/94, and those who have acquired BD subsequently, their appointment should be approved from the date of passing BD. The learned tribunal passed the aforesaid order relying on the judgment of this honorable court in case of Vivekananda Das versus the state reported in 97 to OLR 122, by which this honorable court have held that prior to commencement of Orissa Subordinate Education Service Method of Recruitment and Condition of Service Rules 1993, that is 18/12/93, an untrained graduate was eligible to be appointed against a graduate post with the condition that such appointee would get trained scale of pay only on and from the date of passing of BD. The land tribunal also relied upon the judgment of this honorable court in case of Navin Kumar Beura versus State of Orissa dated 15/5/2001 in OJC number 8377 of 98, whereunder it has been held that creation of post is a mere formality and proposal for creation of post cannot be turned down on the ground that of not taking prior permission, and the judgment of this honorable court in the case of Raghunath Prasad Harichandan versus State of Orissa reported in 93/2002 CLT, page 19.
Give the education manual.
On 17/11/2005, the Honorable High Court of Orissa upheld the order of the Land Tribunal dated 17/7/2003 by dismissing the repetition number 14,895 or 2004, which was filed by the government challenging the order of the tribunal in OA number 405C of 2000 and batch of cases. This honorable court also relied upon the judgment reported in 97 to OLR 122 and volume 93 2002 CLT page 249. The erstwhile on 3/7/2007, the erstwhile inspector of school Sambalpur called upon the headmaster and headmistresses of different schools to submit information regarding additional section teachers for verification, fixing different dates. So far as the school of the appellant is concerned, date was fixed to 11/7/2007 and 12/7/2007. On 10/7/2007, the headmaster of the school in which appellant was working as additional section teacher submitted required information in prescribed pro forma. Consequent upon a reorganization of the field offices of SME department, the school in question came under Bargad District Education Officer. On 22/2015, this honorable court disposed of OJC 8381 of 1998, filed by the appellant to consider the claim of the petitioner. On 2/12/2015, the appellant filed WPC number 21513 of 2002 paying for approval of his appointment. On 7/12/2015, this honorable court disposed of WPC number 21513 of 2015 with the direction to the government respondent number 1 in this appeal to dispose of the representation of the appellant which was at annexure 1 to the said petition within 3 months. On 13/1/2016, as per the order dated 22/2015, after several interdepartmental discussions and communications, the headmaster of Panchayat High School Lakshminagar submitted another format including details of the appellant such as date of resolution of MC, date of appointment, order number, name of the section against which appointed, date of joining, date of passing of BD, and class 10 roll strength in different years from 1991 to 2003-2004. Considering 31/3/2016, considering the representation of the appellant, the respondent number 1 rejected the same on the following grounds. Number 1, appointment of the appellant was in violation of provision of section 5(2) of the Odisha Education Act 1969, inasmuch as no prior permission was obtained by the MC to open additional section in class 10, and thus appointment was against the non-sanctioned post. Second ground, that appointment made by the MC is violative of Rule 5 of the Odisha Education Recruitment and Condition of Service Rules 1974. Assailing the order of the government dated 31/3/2016, the appellant filed this OA number 2094C of 2016 before the land OAT Cuttack, which stood transferred to this honorable court due to abolition of the tribunal and registered as WPC OAC number 2094 of 2016. This honorable court dismissed the WPC OAC number 2094 of 2016, relying on the judgment of the case of State of Odisha versus Navin Kumar Beura reported in 2011 1 OLR 149. Hence, this appeal has been.
Yes, Mr. Roth just referred to as the Rule 5 of the Odisha Education Recruitment Condition of Service
1974 rules.
74 rules. Do you have the Rule 5? The rule is quite categorically mandates that the prior permission is a requirement.
Prior
And that the prior permission has to be forwarded before the month of August every year.
prior permission to the open the section is different. Prior permission for appointment is different.
Yes, both they are saying.
Prior permission for
No.
opening of is under the
No. First of
Education
all,
Act.
there are two aspects in the matter. The one is opening of a new section in class 10. Another is his appointment. Both they have taken stand that his appointment was not preceded by the prior permission of the authority.
Yes. So far as prior permission for opening of section is concerned, I have
No, we are not concerned. We are only about your recruitment because he will not appointed against class 10. He will be appointed against the school.
Yes.
So with that, we understand you show that regarding the sanction, prior sanction before his recruitment, because Rule 5 categorically mandates that such sanction has to be taken prior to appointment. Just come to the Rule 5, procedure of
The
application.
yes, the secretary of the managing committee or the governing body, as the case may be, of an aided educational institution shall on or before 31st of day of August of every year apply to the selection board with a copy of each application to the concerned inspector of schools in respect of schools and director higher education in respect of colleges, in which manner as the selection board may be prescribed the selection of a candidate or candidate for appointment in the vacancies in the teaching post. Appointment in the vacancies or vacancy in the teaching post.
Yes.
So here my submission is that the post was not created. Post facto creation is to be sanctioned. So only after creation only there is a vacancy will be considered there is a vacancy.
All right.
Until and unless it is created, I cannot, management
So
cannot.
according, you go for more in a deep crisis then. When you are appointed, there was no post sanctioned by the competent authority.
The post facto permission was given in view of your lordship may say Education Act Section 5. I have given
When this post facto approval was granted?
post facto approval was not granted, hence I filed the original application.
You are none to take up this issue. This is not your right. It is the problem with the management. If the posts are not granted.
But after taken over, I have to be taken as a government servant. So
you are not appointed according to this rule. You are not at all appointed.
Your lordship may see the note I have given at page 12, what Education Act pre-amended and amended. Page 12 is pre-amended act and page 15 is the amended act. So as on the date of my appointment, there was no necessity of prior permission.
In the year 1992,
92.
this 4 to 5 rules were.
The 5 was inserted in the statute in 1994 under Act 13 of 94.
Another subsequent act came.
So as on the date of my appointment, prior permission to open section or additional section was not there.
No, they have not done it. They have not done it properly. Yes.
That was not there. That is why managing committee couldn't obtain the prior permission.
Yes. Now, what happened? Why have you left in 2001?
I was prevented not to perform. Not.
So you did not got any interim order also. So you now understand that how can you just take the hand of the clock back to that point of time?
But at least I can be approved and paid salary up to the date till I worked. That cannot be.
What is the authentication from the managing committee that you worked on a certain time without any remuneration? Show us.
Now I cannot make managing committee as a party because the school has been taken over and it is under the management of the government.
They are also the managing body. Whether you show some document that you worked during that time with the permission from the managing committee.
You must have shown in the earlier petition, they have been disposed.
That is not disputed. I cannot.
No, this is
Yes,
not
calendar
disputed, but
orders.
you have to pass a positive order that you have to look into those documents.
That can only be ascertained from attendance register, nothing else.
Then
So no,
it is
attendance
your
register-
obligation to produce all the records before this court for passing any order.
When
It
you
is
file,
definitely not the obligation of the state.
when
to
you
produce
filed the
all-
earlier writ petitions, had you not annexed those documents? Because about 6 writ petitions you have filed, that means those documents are not there.
Then documents are there. I have not
Where?
obtained under RTI Act because the attendance is there.
So if it is there,
So,
let it be
if
there.
your lordship will permit me
Because we are,
sometime, I will obtain.
we are concerned with the records of the court.
Yes.
You have not filed
If
anything.
your lordship will permit
now
me sometime, I will obtain
Sorry.
on RTI Act.
No, that it is a appeal under council. Remember this.
That is right.
So we have to decide only whether the judgment passed by the learned single judge is regular or not.
So far as ground number 1 is concerned, prior permission, that was not in the statute book. So on that ground, my case could not have been rejected.
No, that there was no sanction post, whether rule was there or not. A post has to be sanctioned. It is also requires the financial sanction, whether there is a rule or not.
Yes,
Ultimately, the government has to pay the money
that
unless
is-
you do
that
not
is
say.
why I have
no.
annexed another. I have
Sorry,
submitted
Mr. Roth, you come with a better case next time. There is nothing in this your
in
case.
Raghunath Prasad Harichandan's case, this honorable court said post facto sanction is permissible.
And we do not agree with that decision. Court has nothing to do with the post facto sanction of a post. We will direct the government in extreme case when certain people who was engaged, maybe irregular appointment, we find they served this institution for a long time. Court exercise their discretion. This is not a case. From the very beginning, there is no post. He was entertained against a post which did not exist. At least there is no permission. You also admit that now you are asking the court to give the post facto, directing them the post facto approval. Why? Why should we do that?
But that the concept of additional section teacher came in resolution dated 8/7/1981.
Yes.
Their prescription is that in the event roll strength exceeds, so the management cannot conceive of today.
Not today. We are not concerned today. We are concerned when you are engaged, if at all. We do not know.
So at the time of engagement, roll strength was there, roll strength was submitted.
Yes.
From 1991 to 2003, 2004, what was the roll strength that was submitted to the authority? That was not taken into account.
No, then second, if you want to contend that there was a vacancy and against the vacancy you are entertained, then also the permission from the government is required.
Yes.
Now, when they will be satisfied that from 1991, roll strength exceeds and a post is admissible,
Yes.
then thereafter only whether the appointee
That
against
is
that.
the consideration for the administration to decide whether the post will be created or not.
Yes.
Because you have shown that roll strength exceeds the requirement of the further additional teachers is required, then the government in its discretion will consider to create the additional posts.
Yes.
It is nothing to do with your recruitment.
Nothing
As
to
simple
do.
as that.
And simultaneously.
No, because the petitioner has been playing so long as the authorized representative of the managing committee, and at the same time he is contending for his own personal right.
And simultaneously, government is to look into whether the appointee has been regularly appointed or not.
That is the duty of the government. Only when
That
such
is-
permission will be sought, the government will examine the issue. The process will be examined. Usually, I come from a different state. Other state, the government representative is the part of the selection board.
As
And
far
then
as-
it is formally sent for the director of the school education or some other authority for giving the formal approval of the appointment. Then only the appointment letter is issued. Because ultimately the payment of the pay and salaries lies with the government because this is the aided school.
Yes. But
So all this there is not here.
Concept of placing requisition to the selection board
This has not been done.
in respect of this appointment
Yes.
could not have been made because selection board could have returned it that is not a created post.
Obviously,
So-
but they have not done so.
So section 5 violation could not have been said.
No, but there is no permission. There was no post, whether section 5 or not.
So post is to be thought of post facto sanction.
That is why the
That-
court will not
that-
interfere in such matters.
that
Sorry, learned
Post facto
counsel.
sanction was the judgment of this honorable court,
No, that is
consistent
the,
judgment of this
yes,
honorable
yes, we may not agree with that judgment. Because this doesn't lay down the rule, because it is a particular circumstances, the court has passed that judgment.
Yes.
All
that-
the circumstances that principle will not apply.
And that circumstance is also there in my case.
No,
Because
that is
I
not
was a-
there. We do not agree with this
Because
proposition.
there was exceeding of role strength beyond.
No, that's all.
55,
The-
And additional.
That was a
post
requirement of the
required.
creation of the post. Just try to understand this. Service jurisprudence nowadays almost well laid down. That there is no post. How there can be any appointment, even the procedure for the appointment? The answer must be no.
As far as
Whether
my
the
memory
managing
goes,
committee has discharged their obligation for seeking creation for the post or not, that cannot be considered in this case.
As far as my memory goes, as many as 869 such appointments, such posts have been given post facto creation.
Yes,
869.
yes. But this is
Without
this,
selection board appointment, without prior
No, that,
permission for opening.
if you are coming under Article 14, I will say any negative the action of the state which doesn't come.
It's not negative action. It was not required prior to 94.
No,
It was
all right.
Not required prior to 94, so approval was given.
Yes, but the creation of the post, whether it is under rule or not, it is all the administrative action because it involves the financial.
74 rule do not.
I am not going to the rule. I am saying that whether the administration will permit you to create a new post or not, it depends also the financial sanction from a certain department.
Obviously,
That's
financial
all.
sanction,
That is why.
that post facto movement could have been made by the government. That's not prior
Yes,
as per the statute.
yes.
So they have not.
That we have understood this point.
They have not considered
What the
for
government should
post
have
facto
done,
creation.
no, just wait, what the government should have done and what government has not done. That is create a more problem for you because there you admit that there was no post against which you sought to be engaged.
But management felt that an additional teacher is required for the school in the event of exceeding of
That
role
is same. I am telling you,
That's right.
this create additional hurdle for you. That you are sought to be engaged against, there was no post, no permission for creation of the post.
Thinking that post facto permission would be given, post
Sorry,
facto
this is
approval
not
would
a
be
case
given.
where the court will
That
interfere.
was
Sorry, Mr. Rath,
that
sorry.
was the precedent so far as
No,
additional
we are
section-
living under a rule of law. We cannot do, court cannot be pass any order.
And I have for that I have supplied 2 judgments of this honorable court
So what?
post facto approval.
No, this I'm taking this.
Admissible.
It is relating to the particular circumstances.
That additional section teacher. That
The
additional
post will
section.
not, name of the post will not do. I'm talking about the circumstances in which such order has been passed. It is not binding on us, but even by this ethics. Forget about the precedent.
If I will submit the facts of those cases, those are quite similar to my case.
Even if that we will not exercise such kind of a direction in the present circumstances.
Because that prior to 1994, prior permission for creation of post was not in
So
the
don't
statute.
don't
In the
seek the money from the government. That's matter ends there. Ask the managing committee to pay your pay and allowances.
Nowadays, managing committee is not there since
That is why
1994.
That is
Since-
why unless the
Since
government
94,
approves the post.
the school
Even
is of
when a
government.
school is taken over, just here, when the school is taken over, there is initial survey is done regarding the post, the financial involvement of the government, and then only they decide will take over. Even in a lot of incidences are there. I do not know in the state of Orissa is there. They have says to prune this role. Otherwise, we will not take under the granted.
That is there in the 94 resolution, 16/12/94
Yeah,
resolution.
exactly. That is why I'm taking
Even
it.
if that resolution is there, after taken over,
Yes.
701 additional section teacher posts were created by the government.
Yes. Created is all right.
Which were
But in the
which
case
were
where
approved
they have not created, can the court
against
say
the
no?
persons who
Simple.
were
Forget
approved
about
earlier.
this. Can the court direct the government create a post?
No.
That's all.
That,
Better
that,
ends there.
that is the
So if we
settled.
say that create a post facto, it is amounting to exercise that jurisdiction. And we are none to talk this take of whether the post is required. And even you are admitting the managing committee also did not give any
but the
requisition
learned
for
single
creation of the
judge,
post.
learned single judge was to consider the grounds of rejection whether it is genuine or not. ground on which the representation was rejected by the annexure 8.
8 years, yes,
That,
shown
that
as.
was 5.2.
All right.
5.2 then was not in the statute book. So 5.2, section 5.2 of the Education Act could not have been
Was appealing for this
relied
change?
upon by the authority.
Then why have you written when there was no rule 5 in the statute book?
That rule is repealed, that I have seen that.
No, that rule is repealed so far as higher education is concerned, not school and mass education.
But admitted fact.
That printed book I have seen, rule is repealed is there, but that repeal is in respect of higher education. 1992 repealing.
Let's just check out what is it regarding to higher education, the rule that you are showing this book.
In the book, it is there 5 to 8
Will you
repeal.
check up and come at 2?
Yes.
Just check up because this book has very confusing. It's a
That is-
general
that
repeal.
Repealed. Your Lordship.
In book, it is printed as repeal.
That is why just check up with the department.
Yes, ma'am.
At come at 2?
Today.
Because if you get that gazette notification,
All
Tomorrow,
right.
Your Lordship may
Mr.
fix it.
Guntia.
When?
the gazette notification by which it was repealed, that will shed light.
Tomorrow, Your Lordship may fix it.
Tomorrow? All right.
Day after.
Day after?
Tomorrow. I
Heard Mr. HP Ratho and counsel appearing for the appellant in part on admission that the matter will listed on 3rd August 2022 for continuation of hearing. Mr. M.K. Kuntial, an additional government advocate who appears for the respondents, is requested to check up whether the Rule 5 of the Orissa Education within bracket recruitment and conditions of service of teachers and members of the staff of aided educational institutions, close the bracket rules 94, was repealed. And no other provision was substituted in that place at the time when the petitioner was purportedly recruited.
At that time,
That is why that at the time what rule was there, you just bring that.
Yes.
O'Brien.
I will just returning this copy, bring to next date. Call next item,
tomorrow it will come.
day after.
Item 2,
Pardon
pardon my lord, before beginning of the case, I have to say,
Mr. Ratha,
with my lord's permission.
Mr. Ratha, please take your document.
Here, your lordship, I am the petitioner in the, before the learned single judge, your lordship. Here,
Yes.
your lordship, the writ appeal was filed.
Appeal, no, just
Please, I'm
a minute.
Appeal was
It is
filed,
appeal, it has come
challenging
for
the order
admission.
of the Honorable Court.
On the
Whether-
first day, can you have a preference in making a
because
submission?
I was noticed by the registry of the Honorable Court, because I am the petitioner in the, before the single.
My submission,
My
would
humble
be that
submission before lordship.
it has come
whether
fresh.
whether the appellant has got any authority to file the writ appeal or not. Because my lord, I will clarify, because I have
It is
not
a
with-
fresh admission matter.
I
My
have not
learned
supplied
friend
with any
has
copy,
no
your lordship,
competence to make any submission before I make a submission.
Exactly, you just wait, he's right.
because
Just
here
wait.
lordship, I have to participate in this case, your lordship.
No, you will get opportunity after he makes the submission, if you feel necessity, because it is for admission.
Because the appellant has no authority to file this appeal, your lordship, because this is non.
You'll get the opportunity, let us have the
my
some outline
oblige.
facts.
Right.
Yes,
My lord, this appeal arises out of WPC number 12396
yes,
of 22.
yes,
In that writ petition, a prayer was made by, there is a association called Odisha Ministerial Officers Association. That is a state body. And there are also district bodies. The existing district body of the Koraput district was dissolved by the state body, and an ad hoc body was constituted. That was challenged before this honorable court by the existing officers, the pre-existing officers, dissolution officers before
Yes.
this honorable court. My first submission before this honorable court was that the writ petition is not maintainable. That has not
Yes.
been answered by the learned single judge. And he has set aside the dissolution order. My first submission is a writ petition is not maintainable because the opposite parties are neither the petition, nobody is either state or instrumentality of the state, and the opposite parties do not perform any function, any state functions. So writ petition is not maintainable. That has not been answered
The
by the
opposite party means the opposite parties in the
opposite
writ
parties
petition.
in state body authorities.
No, no, in the writ petition, you mean to
Yes,
say?
yes, writ petition.
Okay.
And I had taken that ground in my counter. That has not been answered. And without answering that,
What is the judgment? You come to the judgment because
my lord.
your index is something
It's
missing.
covered with that 4-line order.
My lord.
It is disposed of by that 4-line
No,
order.
that was the second case.
Okay.
2 appeals are there. In the first appeal, judgment has been given. In the second case, it says
Okay.
that it will follow the earlier order. It begins from page
Page, I think,
9. Page 9.
I think judgment start page 12.
Page
12, we come straight to the
Huh?
text of the judgment.
12. My lord.
Printout.
Shall I place it, my lord?
Yes, yes.
The writ petition has been specially assigned to
Right.
this bench. Mr. Ponda, learned advocate, appears on behalf of the petitioner and submits his client is a member of Odisha Ministerial Officers Association, impugned his letter dated 27th April 2022, written by the General Secretary to Collector and District Magistrate Koraput, thereby purporting to appoint ad hoc body and its members. He submits the secretary has acted in excess of his power. There should be interference in striking down impugned order letter. State was not made party by the petitioner. In order dated 17th May 2022, there was direction upon petitioner to add state as party. Since impugned letter stood addressed to functionary of the state, Mr. Ghosh, learned advocate, additional government advocate appears on its behalf. Mr. Das, learned advocate, appears on behalf of opposite party numbers 2 to 5. On query from court, he draws attention to writing dated 5th April 2022, being record of proceedings of extended.
You
executive-
just take your
My lord,
seat.
my lord.
Yes, learned counsel. How the intra-association matter can be the subject matter of Article 226? You
That is
answer.
what my submission is.
Take your seat.
My lord.
You answer
My
this.
lord,
How
my-
that
I'm
can
sorry.
be? How that can be a subject matter of the writ petition?
Here, your lordship. There was a
So we should close down our civil courts,
matter. Civil court is
go to the civil court. We are observing that is a matter not to be adjudicated under Article 226. Your
Madam, here is a-
association,
Madam.
internal matter, ad hoc committee and elect committee replacing your rules, not a statutory rules, it's a mere bylaws of this society.
there is a bylaw, your lordship.
Then
There is a
go.
bylaw.
Read court has nothing to do with this.
Here,
Even
your
the
lordship,
observation of the
my-
learned single judge
I-
to make the state a party is a wrong order. State has no business to interfere with this matter.
My lord, my humble submission, as per my lord's order, the single judge honorable court order. There is a election is going to be held on 12th of this month.
What?
12th of this month, your lordship.
Huh?
There is a election is going to be held on
Ah.
12th of this month. Here, your lordship, my lord is not interfering this.
We are
issue.
not interfering with the
My lord,
election
my lord,
process. We sell the writ
Yes,
petition.
sir.
It was not
My humble
mentionable and that
submission,
was a very
let-
important issue.
Let the present district body may be protected and.
Sorry, I will not give any protection order. You elect, that will be the any dispute, it will
My
go
lord,
to the
my lord.
civil court.
Yes, we are
Sorry.
ready to
Alright,
conduct the election as per
Yes.
my lord's order.
We are not interfering with your election process also. If
My-
they are aggrieved, they will go to the civil court, not to under Article 226.
My-
Yes.
I know your words. But there is a some task, there is a, I have to say something in this case.
It is item number 2.
But-
By means of the writ appeal, the appellants have challenged the judgment dated 12/2022, delivered in WPC number 12396 of 2022, passed by the learned single judge, whereby the learned single judge has observed
11.
principally as follows. Quote para 6.
Okay. Critical account.
Stop. It is an admitted position that the dispute relates to formation of Central Executive Committee as the allegation that has been made in the writ petition is that under clauses 21 or 26 of the bylaws, no power has been given to the Central Committee to form an ad hoc committee without holding the election for this Central Executive Committee. Stop. The bylaws is referred in the para is above quoted. Is the bylaws of a society. Stop. It is a internal dispute between the members of a society. Stop. It has been stated by Mr. Basudev Pujari, Learned Counsel, who is appearing for the appellant, that despite a specific objection relating to the maintainability of the writ petition has been raised, the said question has not been answered by the learned single judge. Stop. The question of maintainability was raised on the ground that no writ can be issued against the opposite parties because they do not come even under the broader definition of Article 12 of the Constitution of India. That apart, the internal disputes of a domestic organization cannot become the subject matter of any writ proceeding. Stop. We have read the entire text of the judgment, and we are totally, and we find the substantive force in the submission of Mr. Pujari, Learned Counsel. You have appeared formally?
For the respondents.
Ah,
You know, yes, I appeared.
all right. Mr. Mohanty, you have not
Yes,
appeared, I
I'm-
think.
I'm petitioning.
You are not a party, how can
No,
you appear?
the court has directed them to implement state as a party.
Collector Koraput.
So the court has directed to them, they have not filed any application in
No,
that.
but in writ appeal, they have,
Stop,
oh, we have nothing to say in this.
all right. You also appeared in the writ petition?
Writ petition was.
Here's the petition. Same council.
Mr. Nilakanta Pandal and counsel has appeared for the writ petitioner opposite party. We've also heard Mr. Writ petitioner respondent. We have heard also Mr. Panda, who has very fairly submitted that the election process is ongoing for election of the Central Executive Committee,
No, the district level committee, district committees.
District Committee.
My lord.
Already. Earlier also the dispute is relating to the District Committee.
There is no dispute at all. There is a, so their party claiming that we are appointed as ad hoc ad
No,
hoc
no,
body.
who created this ad hoc committee? It is the central
Ad hoc
committee.
committee, central committee for
So
which
there
I
is no
appear.
question of election to the central
No, no,
committee.
No, no.
Just you worry about the central committee as a district committee, Koraput, no?
My lord.
My lord.
Stop. Submitted that the election process may be protected by this court. Stop. Having appreciated the submissions of the council from the parties, we are of the view that in such a dispute, the writ petition is not maintainable. Only recourse will be available to aggrieved party to approach the civil court of the competent jurisdiction. Stop. Hence, we hold that the writ petition was not maintainable. Accordingly, we dismiss the writ petition. Stop. In the result, the writ appeal stands allowed. As you will know what it is to cost. Subsequent, the other writ appeal, what is the challenge?
Other writ appeal we had challenged, the central committee had challenged because the district committee officers were not allowing the ad hoc body to function. That is
That
why.
is over here. That
So
was
everything,
over.
these are same, both will
My
say.
lord, my lord.
Both is same. That was now over. Now
right.
the election is going
Same
to
order, common order, huh? There is also this same date order was passed,
on the
Same
same
one.
date it was disposed.
It was-
On the
the
same date was
analogous
disposed,
hearing
but
was
challenge
made.
the order.
common order.
Common order.
Common order.
So this common order, huh? So this is all right.
Humble submission, your lordship. One word maybe. Any election maybe. As per the.
We will not say anything, then we'll be exercising, we'll be the guilty of the
They
same
are
thing what
aggrieved. They are
Learned
going
Single
to
Judge
be-
has done.
They
No,
have filed the
sorry.
case. They are the aggrieved.
So
They-
go on, we have not observed anything. You go on. If you can continue,
I
continue.
cannot. This urgent certified copy, your lordship.
Item 3. Item 3, may I please?
Yes.
In this writ application, may I see the present petitioner is challenging the illegal and arbitrary action of the opposite party in publishing the illegal notification, which is annexed in Annexure 1, 25/8/122.
Yes, how it is, you have given English translation. So you don't want me to read this annexure 1?
In Odia, that is written.
I cannot read Oriya. That is my disadvantage. So what to do? You take time and get a translated copy,
Translated copy. I will file.
10th of August. So it will coming in on
Nice.
24th of August,
Nice.
right? At the request
Only
of-
in this case, there is only prayer. Already a Anganwadi center is functioning at one place. For government had notified in to establish another Anganwadi center, and selection procedure has not been made. The selection the government stated that the selection procedure will be made from the only ST category. For that reason, that
In the
What-
meantime, selection process is completed and someone has got appointment.
That is what is the notification? Let me dispose of the matter then.
then my repentation is also annexed in 12 page 12 minutes.
Notification. No, this is
আবেদন
advertisement.
নিমন্তে
It
নিয়ম
says a
করে।
copy of the notification dated 25/8
Where is the copy of the notification?
as page 7 of
Oh,
the
sorry,
petition.
this is the.
Page 12 is my repentation is there.
No, this is a writ petition.
7 is your the notification
Annexure 2 is
That
my
is the
repentation.
For applications.
for recruitment.
Yes.
Before the-
Care Talika.
Now, how it can be a subject matter of the public interest litigation?
Public interest litigation allegation. My
First
only
of
that-
all, there is a broader principle the Supreme Court has already laid. You cannot challenge appointment of an individual.
the government notified to establish the
Government
Anganwadi
may
center
be maintaining a
on the forest
roster.
area or
That is
without
the
on the forest area
establishment.
without no NOC from the
You are
forest
challenging
department.
the establishment of the Anganwadi center.
For that reason,
Why?
already a Anganwadi center is there
For
on
you
the
to decide that if on the survey it is found that the another Anganwadi, you are coming to the services that is being expanded, you are coming against that.
It is for your benefit.
You are against the public interest, Mr. Jena.
What is your genuine grievance is what?
All right. No, I understand that because there is some interest is there. Heard Mr. PC Jena. Right?
PC Das Miles, PC Das Miles,
PC Das.
Miles.
PC Das and Council.
Selected only they are coming candidate selected only from the ST category. For
No, that
That-
will
that
not
not-
be
That
public
they can do.
interest.
If that area is consists
Area is
that
forest area.
community, they can do.
And council appearing for the petitioner. In the garb of this public interest litigation, the petitioner has prayed before this court to coerce the notification number 993 dated 25/8/2022 under Annexure 1 to this petition, whereby the establishment of a new Anganwadi center and engagement of new Anganwadi worker has been notified. And whereby establishment of a new Anganwadi worker has been declared, and applications
Have been invited.
for recruitment or engagement of Anganwadi workers at Siding Sahi under Dhobashila Gram Panchayat of Nilgiri Block under Balasore district has been invited.
25/8/2022.
Ah.
Annexure 1.
So that apart, it has been stated by Mr. Das and counsel appearing for the petitioner that a representation has been filed to the collector Balasore raising objection about establishment of the said Anganwadi center. All right, Annexure 2 to the representation, then Annexure 2, under these petition. So Mr. M.K. Kuntial, an additional government advocate appearing for the opposite parties, has clearly stated that the recruitment process is over. Stop. Be that as it may, in our considered view, under a public interest litigation, the petitioner cannot be permitted to challenge the state's program for expanding the services for the children by enhancing the number of Anganwadi center and also recruiting the Anganwadi worker for that center. Stop. The action that's taken by the government and is reflected in the notification dated 25/8/2022, it does only serve the public interest, and as such, this petition stands dismissed. All right.
Item 4, Legislators.
May I please alert?
Yes.
Here, my lord, I am challenging the order passed by the collector district magistrate Sundargarh, who leased out the government plot, which is a forest land, my lord, to the IDCO, my lord, without due process.
You show me the document how it is a forest land.
My lord, kindly see annexure.
Is it a forest land?
Annexure
Mr. Mohanty? Mr. Mohanty, is it forest land?
My lord, he's relying upon the record of right. I have to take the instruction what is there because today is the
Already we are issuing notice. Heard Mr. SSK Naik, SS Naik.
SSK Naik.
All right, SSK Naik.
Defect number 11, legible copies of so many pages are required. Page 50, 61 to 64, 67 to 69, nothing is visible.
There are pages 20 and 21 not legible.
Which matter?
My lord, I will.
This is in the course of the day you replace, we are issuing notice.
My lord.
This pages 20 and 21. You take note, 2021 is not readable.
My lord.
You change these pages by typed copy. SSK Naik, Planet Council appearing to the petitioner. The grievances enumerated in this public interest litigation is that the state is converting the forest land for use of the IDCO,
IDCO.
ID Industrial Development Corporation of Orissa, IDCO in short, Bhubaneswar, stuff. Whatever the grievances we cannot stop. It is the allegation of the petitioner that the conversion of the forest land is illegal and without any procedure that is prescribed by law. Stop. Issue notice returnable on 4th of September 2023. Since Mr. D.K. Mohanty, National Government Advocate, appears in web's notice for the
Opposite part number 1, 2, 3, 4, and 5. So far as 6 is concerned, your lordship. Beautiful.
there's just the after the regarding the conversion of the forest land. Stop. This stop. It has not been asserted anywhere that whether that land is covered by the protected forest, covered under the protected forest, on the reserve forest.
Reserve.
Stop. But this issue as raised by the petitioner is of public importance if the land falls under those two categories of forest. Hence issue notice such and such. Since Mr. D.K. Mohanty, learned Additional Government Advocate, appears in web's notice for respondents number 1, opposite parties number 1 to 5, no formal notice is called for in respect of those respondents. The petitioner shall supply 2 additional copies of the writ petitions to Mr. Mohanty in the course of the day. That apart, the petitioner shall take steps for service of notice on the opposite party number 6 by registered post with AD within 3 days from today. All right.
Item 5.
Because my sister has pointed out that it is jungle land. Not all jungle land is not necessarily the reserve forest or the protected
Jungle land, that
forest.
too in the Sabi Karovar, Hal Arwar.
Sabi Karovar. That is the only evidence in favor of the petitioner.
That is why asking you to just check up this
No,
matter.
I will check up. I will ask the Tahsildar to give a detailed report. What
Please.
is the current status? And add to it, your lordship will kindly see, transfer of jungle Kisamula land is not prohibited.
No, because of the Forest Act, Indian Forest Act, there is 2 segments. There are 2 kinds of forest are there. And the state government cannot unilaterally convert any land if it comes under the protected forest and the reserve forest,
Yes.
both. It is a principally the central government's
Yes,
domain. So just check up this matter.
Whether it is coming under those 2 categories.
Come to this category or not.
Right.
Just
God bless.
Your lordship is fixing it.
5.
Item 5.
4th of September.
4th.
4th of September? Notice is returnable on 4th of September. Yes.
Hal Arwar says Patita.
They converted it to Patita.
Already converted to Patita.
All right, let us see.
Item 5.
He is challenging this
But in
conversion.
case, the
Yes, Mr. Kaur.
The prayer in WPC number 7508 of 2010 was basically a OEA matter, Orissa State Abolition matter.
Another
Okay.
bench, I think.
That's a division bench matter, but it was inadvertently had and disposed of by the Honorable Single Judge.
Now we'll hear it.
Mhm.
Without going by the technicalities, we'll hear the matter on merit.
Right, but your lordship. is-
Because wrongly or rightly an order has been passed. If you raise a question of jurisdiction, at best we'll set aside that order. And ultimately we have to decide on merit.
My lord,
Let me do the same thing in the appeal.
My
They are
lord.
not the
All right.
assigned
But-
bench first.
Writ appeal, I will argue on merits, but at the moment, the review be disposed of by the Honorable Single Judge. That is posted, I think.
But you filed the appeal. You filed the-
Simultaneously, he has filed the appeal and another.
I'm just reminding you. Order 47 Rule 1 starts with, you remember we are a seasoned campaigner in this court. It starts with, if appeal not filed, only you can exercise the review jurisdiction. Right? So if you insist on the review that we will dismiss this appeal, that a review is pending, after the result of the review, whether the appellant will file appeal or not, that will be decided by the appellant, not by the court. Am I clear to you?
Yes, madam.
So you cannot at the same time sail on the two boats.
Well, by humble submission, the writ appeal has been filed keeping in view of the limitation.
Ah.
For abundant caution, writ appeal has been filed.
No question of abundant caution, you cannot file. Give the CPC. I am reading the provision. We follow the principle of CPC so far the review is concerned.
And
I am
maybe
reading the verbatim
Yes,
provision.
so far as the impugned order is concerned, that is not under the OE Act. This is coming under the Orissa Survey and Settlement, which is assigned to single bench.
No,
But
no.
yes.
Matter is
You
related.
see, the impugned order before the honorable single judge
No,
was
just on the
Yes.
face of his objection.
Yes.
We are on the whether the review or
whether the appeal is maintainable during pendency of the review.
just I am reading this this rule 1 I was referring, order 47. Any person considering himself aggrieved, A, by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, then only can file the. How can you just sail on the two boats together? Law prohibits.
Well,
Not a question of abundant caution.
Your Lordship is right.
Ah.
I cannot file both review and writ appeal at the same time.
Yes,
But in view of order 47,
yes.
here my humble submission is let me be given some time so that I will think of whether I will withdraw the review and pursue the writ appeal.
Yes, we have no difficulty. September 4.
Review petition is 122 of 20.
All right, no, he is taking time to decide on. At the request of Mr. S.N. Kaur, and counsel appearing for the appellant, let the matter be listed on 4/9/2023. We have noticed that it has been informed to us that appellant has also filed a review petition against the same judgment which has been challenged in this writ appeal. Stop. Let the appellant take a call which forum he would pursue the remedy. Stop. Mr. D.K. Mohanty, an regional government advocate, has appeared for the respondents.
What
4th of September.
What is the review number?
122 of 2023.
23.
Yes, RVWP.
That is also listed
That is
before us.
also listed along with this.
No. Why this? This by order of the court, it has been listed along with. What we will do with the review petition? We do not have any jurisdiction. We are detagging the matter. Sorry. The release the brief of RVWPAT 122/2023 be detect and shall be placed before the appropriate court if any date is fixed for that purpose.
Yes, adjourn to 14.
All right. Next.
Item 6.
The 6, my lord, at the mentioning stage I was submitting.
Yes.
At page 38, my prayer is to hold and declare the impugned memorandum of charge under annexure 1.
All right. Not you have not challenged the
Not
rule.
the rule.
All right. All right. Mr. Digambar Mistral and counsel appearing for the petitioner has submitted that this court doesn't have any assignment as the matter is to be placed before the single judge. In view of this, registry is directed to place the matter before the appropriate bench having assignment. Stop. All right. It will be now listed before the another bench.
But may I pray only any date?
No.
We cannot fix it. Is according to the they will give the date.
Madam,
Yes.
I move.
Item 7.
May I please, your lordship?
Yes.
This is a case, my lord. The opposite party number 4 has encroached some government lands, unauthorizedly constructing a house
All right.
He has already.
Here, Mr. Roth,
My lord.
heard Mr. Mihir Kantu Roth, Land Council, appearing for the petitioner. By means of this public interest litigation, petitioner has questioned the occupation of the opposite party number 4 on a government land. Encroachment of the opposite party number on a government land. Stop. Issue notice returnable on 4/9/2023. Since Mr. D.K. Mohanty, learned
1 to 3.
additional government advocate appears in notice for the opposite parties number 1 to 3. No formal notice is called for in respect of those opposite party. However, the petitioner shall take steps for service of notice on the opposite party number 4. Stop. Let us see on the next date.
My lord.
You texted within 3 days.
My lord. Yes.
Only on 4 I'm supplying him an additional copy.
Yes, my lord.
I'm not reflecting one additional.
A notice to open up for through registered post, my lord.
Registered for 3 days.
My lord.
All right.
Item 8. Obliged.
Item 8 here, my lord, the public litigation from the government land that is for the veterinary hospital, my lord. So some persons are forcibly encroach the land and continuing construction. I made reference to the collector and so tahsildars. Till date no action was taken.
What do you mean by the land mafias? Are the land
That is for
mafias
the-
a bit?
Veterinary hospital, my lord, that land is, that hospital is there.
You have not named them.
No encroacher is implicated as a part.
No, you have not specified any areas of land when such encroachment is there. You simply says the land mafias.
No, my lord, there is.
No, what is the word? Land mafias who? They are persons and they are the spirits. You must add them because you are making allegation against them. Who are the unidentified people? How can you direct?
There's so many persons, sir. Only my prayer, my lord, let that government take action, my lord, because it is a government land. So many persons are illegally encroached and
Where was the person? Where have you stated the names of the person? Have you? And you have stated.
You are saying so many persons, at least name some.
not named any person, my lord.
Sorry?
I'm not named any
No,
person.
no, you said there are many persons. Name some at least, even if not all.
How can you just direct the government? How to identify those land who according to you under occupation of some unauthorized person?
I think connivance with the
Land is
government.
only for specific
officials.
for the government hospital, that land, only the specific land.
But you have to give a specific land and the name of the person with whom the government officer is conniving. You take back the petition with better particular, you file again.
I filed the name of the addition.
Now the file again, take back this application for the time being, file a new petition, will say that you are withdrawing for filing a fresh petition with better particulars, right? You file a memo then.
My lord.
Show some land. You are Mr. Das.
My lord.
Mr. Saroj Kumar Das, Land Council, appearing to the petitioner, has stated that he has instructions to withdraw the petition with liberty reserved to file a fresh petition with better particulars. You file a one memo, one liner in his. In this regard, also a memorandum seeking leave to withdraw has been filed. A memorandum seeking leave to withdraw has been filed. Stop. We do not find any impediment to allowing the said prayer. Accordingly, this petition stands dismissed as withdrawn with liberty reserved in favor of the petitioner to file a fresh petition with better particulars, or if a fresh circumstances arise to approach this court, Mr. D.K. Mohanty, learned additional government advocate, has appeared for the opposite parties. Next.
Item 9.
Five acre 115 decimals of land.
For a medical college.
My lord, for establishment of some hostel to.
Now, how
campus,
it
my lord.
affects the public interest? Mr.
My
Patnaik?
lord, this area is coming under archaeological department as well as Prachi River Valley, and also, my lord, this has been leased out within very.
But your
lesser value,
allegation,
my lord.
that they are parting with the land with a very less price.
My lord, and
Or
also,
the
my lord,
archaeological of India
That
matter is
also.
not there in your prayer also.
my lord, I pray for this is the land scam, my lord, and the officer of the state government are involved in leasing out this a commercial basis private hospital, my lord, near the prime location of the Twin City, my lord, and which is near to NS5, my lord.
That is against the government policy, that establishment of medical college and hospital.
My lord.
Is it against public policy? I mean,
No, that is what we are asking you. That setting up of a hospital even by the private agencies
Private.
or
My
enterprises.
lord, there is several private hospitals, and without
Who are
invite-
who are you to decide it? You have elected the
My-
government.
My lord, that has not been decided by the cabinet or any inviting any tender, my lord, from the
No.
intending, my lord, private hospital
that
owners,
is
my
not
lord.
necessary. Somebody makes an application, they grant land.
No, that is the government is encouraging to the private enterprising coming into the health sector. So the more hospitals. But what happens, I'm telling you, Mr. Patnaik, you may not know. We have a good government hospitals, but those hospitals are overcrowded. By whom? By those who can afford take the Medicare service from a private hospital. If there is sufficient number of the private hospital comes up, then these people will go there.
Man.
And the poor people, marginalized people who really needs the government service, so for the Medicare is concerned, they can get the better help. The doctors will be the less pressurized.
The commercial basis hospital, it is commercial.
It's true. Everybody's because we are concerned about these hospitals.
Those who can afford will
Those
go
who
there.
can afford, they will go there.
And
The
this-
slice of the medical population who requiring the medical care and attendance, they will be just shifted over those hospitals.
You saw during COVID time, private hospitals.
Suppose I
only
give an
people
example.
could go.
Mr. Mohanty is there.
Man.
He will never will go to the government hospital. He will go to either the Apollo hospital or the similar other
But
hospitals, the
when
Oshini
I
hospital.
suffered from COVID, I went to the government.
Because
hospital.
at that time, the private hospitals were not admitting the patients. That is the reason, Mr. Mohanty.
And you would get better treatment at the government hospital because of your.
No,
Status.
that's my lord, so far as these institutes, opposite partner 17 is concerned, his existing medical is also there in Bhubaneswar.
They have a
Some
medical
hospital.
college also. I think.
Medical college. Why?
No, anyway, that
What?
only the
Yes,
only
yes,
the issue that
wait,
you have
wait,
raised.
You are saying why it has been given? What are you saying?
No. I'm not saying that. Why he is objecting that
He
is
is
right, because he has got a good infrastructure, everything is there. So
Objecting is that this
Low
is
price.
the main thing. You are parting with the lands with a very less price. Whether that is a part of it, because it is a after
Prime
this,
land.
no, after this Ashwini Upadhyay's case, Supreme Court in 2014, that you cannot the public resources you cannot just barter away without assessing their proper price. They read the prayer, Mr.
yes, my lord, I have.
Mohanty.
Yes,
115 page. Sorry, consideration.
If you are doing that, you showing some favors to a particular institute or the enterprise, that is definitely against the public interest. We have no difficulty.
15 crores.
The government is correct, perhaps enterprise is encouraging the private enterprises to set up hospitals. They are right. We have no difficulty in understanding that. But if you are this public resources, you are barter away in the lesser price.
15 crores, 34 lakhs, as he has.
Which is lesser than the benchmark value he's saying.
The benchmark value is decided also by you. Benchmark value is decided for purpose of registration of the deeds by the revenue authority, that nobody can be allowed to just register a deed showing the price below that. Even the price is below that, he has to pay the government fees.
Government
And
fees.
And he's
registration.
saying what
Otherwise the
procedure
deed will be
did you
formed.
follow? What procedure did you follow to allot? Can the official just do it, or there is some cabinet approval is necessary or not? He's
In
saying
that case, I have to file the
I think
response
they
affidavit.
constitute a committee authorizing that they can
Your
decide.
lordship's query, I understand. If your
So we are
lordship
not
is-
issuing a notice, you take the instruction. We are not issuing any notice. We are asking you to take instruction.
Should I file a response affidavit?
You can file also, that will permit
I
you.
will file a response. That will be
Yes,
better.
heard
so that-
Mr. A. Patnaik and counsel appearing for the petitioner. The issue notice returnable on 21st August 2023. Meanwhile, since Mr. D.K. Mohantil and counsel appears in Webb's notice
For 1, 2, 3, 5, 6, 8, 9
1, 2,
and
3,
16.
5, 6.
8, 9 and 16.
All right. Have you taken note? No formal notice is called for. No, you can also appear for those persons. This director, oh no, sorry, the director, Vigilance Odisha.
No, Vigilance Department is having a separate panel. The Director of Vigilance, they are having a separate panel of lawyers. Not
All right.
one.
The petitioner shall take steps for service of notice. Everybody. On the remaining opposite parties by registered post with AD within 3 days. You take the steps within 3 days.
My lord.
Accept the numbers he is quoted or take steps for service on all other respondents.
My lord.
With the central government council, you can, this for Director of Archaeological Survey of India,
Archaeological.
can you
yes.
accept the notice?
We can,
Director CBI perhaps you cannot do.
no, I am not
No.
CBI. I am the archaeological survey.
My lord, I saw the document.
Whether the National Highway Authority or separate council.
Separate council.
Stop.
My lord. So
Mr. J.
far
Naik,
as
London,
CBI is
Central
concerned,
Government
no
Council.
notice be
Ah,
issued right now
can-
because,
appears in Webb's notice for the,
my lord, so far as CBI is concerned, my respectful submission is no notice be issued right now because if your lordship is not accepting my submission from the counter affidavit and your lordship will come to a conclusion that is a
only
Yeah.
CBI.
only CBI. Others are necessary parties for adjudication. So
But
far as
regarding the Director of Vigilance, you have no problem.
No, yes, I'm sorry, Director of Vigilance. They are the
All right.
investigating agents.
Notice-
They will only be taxed with the
But no
investigation.
notice. But we are not issuing any notice, just after that issue notice, but we are not issuing notice on the opposite parties number
6,
12 and 14. Let the police commissioner come. The
police
Director General of
yes,
Police, let
police
him come.
concern.
You can also say the 14 can be also because it is under your control.
No, control.
12,
no,
14,
that 12 and 14.
12 and 14.
Yes.
That presents. Stop. So the 12 and 14, Mr. Patnaik,
My lord.
you don't issue notice,
My
we are
lord.
excluding them. All right.
And 15 may be notice, Commissioner of Endowment.
14, 15 also.
15, 1-5.
No,
Yes,
notice, we have already issued notice also.
May I pray your lordship to keep it in first week of
13 he
September?
agrees, then 13 may be given. All right, 12, 13 and 14, 3. All right, 12, 13 and 14. So to 12, 13 and 14 you exclude, no steps is
My
required.
lord.
My lord, may I request it to keep it in first week of September?
No, 21st.
Oh,
The-
obliged.
This matter now you do
Yes.
not know. And Mr. Patnaik is a very influential person because he is representing a newspaper.
Newspaper.
Tomorrow you don't know what will be coming in the newspaper. So immediately you respond.
Yes.
Let it be there. Yes.
Item 10.
May I please your lordship, my lord?
Yes.
This is the case of public interest litigation filed by the Sarpanch of the Chandol Gram Panchayat, alleging that, Lord, the collector opinion number 1 has opened the offshore and given the license, which was objected by the Sarpanch. Page 18, annexure 2. Last occasion, my lordship directed the
What is the ground of the objection?
yes, my lord. as because that
Where is your objection? That is annexure
Page-
2?
and page 18 answer 2.
All right.
That is a 510 meters from the Kontri Shishu Shiksha Niketan. That the Shishu Mandir.
And the rules provide 500
Yes,
meters.
yes, that there are two things which I bring to notice of my lord. But one is the Odisha Excise Act, and another is the
Rules.
Odisha Excise Rules.
Yes.
Odisha Excise Rules I bring to notice. Rule 26, my lord. License for shop for consumption of the liquor on the vendors premises not to be granted at certain place. No shop shall be licensed for the consumption of the liquor on the vendors premises.
May I submit one thing, Your Lordship? This is not a new shop. Your Lordship may kindly see. These licenses are granted since long. As a matter of routine, it is renewed each year. And these rules are applicable when this new proposals
No,
are
I
submitted.
understand.
So so far as this particular license is concerned, it is a renewal case, and renewal there is a formal objection invited, and if there is no objection, it is regular as a routine manner. It is renewed.
What
Not
do you
that-
mean by formal objection?
No, that objection was invited. He never. So all these
He has
objections
filed
are.
the representation page 18.
Yes.
See that representation at
Yes,
page
my lord.
18 of the writ petition.
Yes, madam.
He has given the 6 installations. This is a very important, this is important according to him. This population as a
Yes.
whole is being affected
So
for the
may I
present.
suggest subject to your lordship?
No, he is
Your-
not against renewal. Just see the
Your
prayer.
lordship may kindly
He
ask
said
the
to shift
collector.
to some other place.
Yes. Collector will examine all these things and.
All right,
because-
that is why I'm saying I'm
yes, your
disposing of the
lordship.
petition.
Collector
Directing
Kendrapada,
the
he is the
collector
licensing
exception, the
authority.
objection even required, collection will provide you the personal hearing.
Yes, my lord, that is
Right.
okay.
Yes,
Yes.
personal hearing is that, ma'am.
Personal visit of the Sarpanch.
My lord.
So then they will be personal decide. Because he is the authority to decide. on
Yes,
it.
collector is
All
the
right.
authority.
And this is a violence, my lord. Has,
Oh, he will see how collector will take a decision.
That you are only referring to the rule 26 of the Orissa access rules.
and also, my lord, section 27 of the Odisha Excise Act also.
What is 27 says?
Yes, my lord. Restriction of the grant of license on exclusive privilege. My lord, A. One, notwithstanding anything contained in the chapter of the elsewhere in this act in the schedule area.
Yes.
A. In no case there shall be granted under this act any license for the manufacture, possession or sale or any exclusive privilege for manufacture or sale or intercity except with the prior approval of the concerned Gram Panchayat accorded with the consent of the Gram Sassan. And B. No license or exclusive privilege which is granted in contravention of the clause A shall have any effect to the purpose of this act. For the purpose of clause A, subclause 1, the authority competent to grant a license of manufacture, possession, sale or exclusive privilege or manufacture, sale or any interest shall, before granting such license or exclusive privilege, refer every proposal thereof to the concerned Gram Panchayat for its decision within a period of 30 days from the date of receipt of the such reference.
Lordship may
And if
indicate
the
that-
Gram Panchayat failed to communicate its decision within a period of
Lordship may
30 days, it
indicate
shall
they
be
will-
deemed to them.
Collector will take care of these rules and acts.
So
and
See,
pass
the-
them to
Mr. Naik, since
Madam.
you are referring to the rule, you are asked to give your objections by 2012-2022.
My lord.
You have posted this on 19/12/2022.
My lord, I am posting in the Kendrapada. That
Wherever it goes on the same day.
same day, no,
Then-
before one day. Is the 20 day,
So why?
the date, day was
You have
20,
been given
I am
1
the-
month time.
and that was the reach on the, they are received on that day also because of,
Receive
the
acknowledgement is not.
You have the ID.
No,
You have the
No,
ID
I-
with you.
there is no acknowledgement.
I have to,
If you have the ID, well, very good.
no, I have the postal receipt.
I have seen the postal receipt and showing that it is 19/12/2022.
1912.
Yes.
It's 1912.
Heard Mr. Jyotish Naik and counsel appealing to the petitioner. By means of this writ petition, the writ petitioner, who is the Sarpanch of Chandol Gram Panchayat,
Chandol Gram.
Chandolo GP.
is ours before this court for directing the opposite party number one in particular for shifting the liquor shop from the present
IMFL restaurant on shop and beer parlor.
uh,
IMFL
IMFL on
restaurant
shop and
and
beer
beer
parlor.
IMFL and
IMFL on shop,
on shop.
on shop and beer parlor.
Separate shops.
And
No, one shop.
same, and beer
Parlor.
parlor.
No, it says Chandol beer parlor. So where is the IMFL on shop?
On shop nahi, khali beer.
Serial number 20. Chandolo beer parlor.
Yes, my lord.
Yes.
And next, my lord, page 15.
Oh, there are two shops.
Ah, so that is what I'm saying.
There are
He's
two-
objecting
Page
to two
15,
shops.
that is
Two
the,
shops side by side.
my lord.
Shops are side by side.
My
Same,
lord, that
same owners.
And no, same
owner,
village.
there are two.
And it is your case that there are no existing shops in Chandol.
No, there is a off shop. On shop is there. And there is the within the
Just a
500
minute.
meter of the
Just a minute. Are there any shops in Chandol? Existing shops?
no.
No shops. These are proposed shops where there are no other shops.
No, these are old
Except
shops.
these-
No. Old shops maybe. No other shops. Because other selective
Still, to shape the shops to a place
outside Chandol. Gram Panchayat.
and outside the said Gram Panchayat. So, it has been stated by Mr. Naik that the petitioner had also filed an objection in response to the notification dated 249, notification number 2489 and 3491 dated 6/12/2022 issued by the District Excise Office Kendrapara. Stop. In the said notification, he has provided the grounds of raising such objection.
Representation.
When the said representative provided the grounds of the why he had been objecting in respect of the location of the said shop. The shop IMFL and the beer parlor. So, Mr. Naik has further submitted that while granting the license in favor of the
Opening of the
license
for the shops.
license for the shop,
Shops.
the provisions of shops for the provisions of section 27 of the Orissa Excise Act 2008 and section 26 of Orissa Excise Rules 2017.
Rule 26.
Rule 26 of the Orissa Excise Rule 2017. First is an act, na? 27 is the section 27 and the rule 26 of the Orissa rules such and such. But not taken any care. Stop. Mr. This Chandul Gram, this to shift the shop from Chandul Gram Panchayat, Chandur Bazaar within bracket the marketplace. Stop.
No other
We
shops.
will not make any comment on the merit of the objection. But a responsible citizen has come forward to represent the grievance of the public at large. Stop. That is the reason why we directed the opposite party number one, the collector, District Kendrapara,
Kendrapara.
to consider the representation of the petitioner. Representation dated 19/12/2022 of the petitioner. Annexure 2 to this petition. After affording an opportunity of personal hearing to the petitioner within a period of 30 days.
After affording opportunity
Ah,
to the
that's it.
licensee.
After a period of within a period of 30 days from the date when the petitioner shall produce a certified copy of this order
This extra.
to the opposite party number 1. Stop. In terms of the above, this petition stands disposed of. Before that, Mr. D.K. Mohanty, additional government advocate, has appeared for the opposite parties. Stop. And then let them consider we not for a reason we have not.
Urgent copy.
On behalf of Mr. Swami Mallards, similar matter has been posted 21st August Mallards.
What is your good name?
My name is Atul Tripathi Mallards.
Mr. Atul Tripathi Land Council appearing for the petitioner has stated that, appearing on instruction, Mr. Kaushik Swaina has stated that the analogous matters are posted on 21st August 2023. That the matter will be listed on 21st June 2023.
Yes.
13.
Ms. Patnaik, are you appearing in this matter 11?
Let them serve copy on us, Madam. They're not served copy on us.
11. In the meanwhile, the defects number 6, 11 and 1A are to be removed by the petitioner. Stop. It is made absolutely clear if the defects are not removed, the petitioner will be debarred from making any submission on that date. And as a copy of this writ petition be supplied to the Ms. S. Patnaik, petitioner government advocate, who has appeared for the opposite parties on instruction. In the course of the day.
I'll inform. Yes.
All right.
Item 13, on behalf of Mr. Pradhan, adjourn the matter to next week.
No, this is a matter where FIR was not registered.
No, if we have done it on 15 now. Oh, in the meanwhile, sorry, this call in.
Mr. Panda, you remove the defects in the meanwhile.
You remove the defects. Just tell her to just add a line, take down the line. In the meanwhile, the remove these defects is identified by the registry shall be removed. Oh, it is not coming. No order.
No steps taken. Order 3 may be seen. Order is there, but naturally no steps. Not necessary because we don't proceed without that.
16.
Once it was dismissed.
Madam, 1 week time may be granted for removal of defects.
Yes.
1 week time may be granted for removal of defects. 1 week time may be granted for removal of defects.
Once this petition
was
was
once
dismissed
dismissed
for
for default.
non-prosecution.
For non-removal of defect. Again, it was restored. Again, he is seeking back.
Again, peremptory order is passed.
Why are you seeking time?
Under at least 2 days time may be granted.
This is anyway contractual matter.
The Lordship will see the impugned order.
I think your writ petition has become infractuous. Just see
The
the
amount.
just you come to the page 20 of your writ petition. Do you have a brief?
Yes, ma'am.
Are the brief with
On
the
behalf of
papers
Mr.
with you?
My lord, on behalf of Mr. Misra,
We understand that. We don't like to see a counsel who is only say on the instruction of such and such. Unless your senior give you the brief to you,
yes, my lord.
should not appear. You are not to be embarrassed in the court. We are asking you certain things, you must answer this. Just what is the prayer? In view of the above facts and circumstances, it is most humbly prayed that the Honorable Court may graciously please to admit this appeal, call for records, and after hearing the same, please to set aside the impugned order dated passed in WPC number such and such, and consequently the order dated 29 passed by the respondent number 3 for the interest of justice and equity. What is those orders? Have you gone through the records?
No, my lord.
Have you gone through the records?
No, my lord.
We'll dismiss the appeal again.
Kindly 2 days time may be granted for.
No, we have no time to give you. Very precious. Earlier occasion also, you did not appear. Court was forced to dismiss this for non-prosecution. You are seeking time today after knowing that you just occupy a very vulnerable position so far the proceeding is concerned. All right. Only are seeing this decision, we are admitting him time. All right.
Yes. But
Let the matter be listed on 25th of August 2023. What is your good name?
Rosmikant Sahu. Rosmikant Sahu.
Lakshmikant.
Rosmikant R.K. Sahu.
The request of Mr. R.K. Saul and counsel appearing on instruction of Mr. K. Mishra
Yes, ma'am.
and counsel for the appellant. Mr. D.K. Mohantil and counsel appears for the opposite parties.
Item
Mr.
18.
Mohantil is just only seeing the royalty is not a matter of contract.
no, the view of the Honorable Single Judge is that there is a disputed question of fact. He is
No,
claiming.
that is a separate issue. But he says the royalty is an issue of a contract. Royalty always is not an issue of a contract.
No, royalty is
So what the
different.
government is a issue of a statutory rules.
Yes.
Right? That whether under rules he is entitled to not, this is beyond the agreement. Other part, the facts may impact, we cannot decide that part.
Royalty part will not come within the ambit of
And
agreement.
that we'll see. That is why I'm granting him time, and moreover, he doesn't know anything of the case. It is made absolutely clear if on that day there is no substantive representation, this court will be persuaded to pass an order for non-prosecution. And in the meanwhile, the appellant shall remove the defects as identified by the registry.
Okay.
Item 18.
Yes.
May I please? And on the last occasion, this Honorable Court directed the government to take instruction with regard to the document at Annexure 2 dated 20 at page 58, my lord.
Yes.
Yes, my lord.
56, 56.
No, before that, there is
I want to.
by the order dated 3/5/2023, Mr. Kuntia, you are directed. Have you filed any affidavit? Just come to this order dated 3/5/2023. Could I read out the order for
Yes,
your
my
benefit?
lord, that I am summoned. My lord, only 1 week. I need 1 week. I'll take instruction. At that last occasion, my
More
lordship, I
than 2
directed.
months have gone.
All right. At the request of Mr. M.K. Kuntial and additional government advocate, let the matter be listed on 14th August 2023. The opposite parties are to comply the order dated 3/5/2023 by this time. Mr. M.K. Potil and counsel has appeared for the appellant. What is?
disposed of, there is no delay.
IA 1893. Yes, there is no delay. This petition is inessential and accordingly the same is disposed of. All right. 14th, we will try to hear the matter on merit.
Yes, yes.
Next.
Item 19.
19, somebody was mentioned, he wanted
What was the prayer?
prayer was condemnation of delay at the time of mention.
Concept that
Oh, condonation of delay.
What about the defects?
Millard, the order was passed
9022, let me see
on
what it
on
is.
this
Is there any
29th of
Let me see
April.
what it is. Oh my God,
But the
so many defects.
This petition suffers from as many as 15 defects according to them.
sir, in fact, the defects are pointed out regarding the margin of the.
It's a very important defect
But I cannot rectify.
because now our documents are getting scanned. If you just use the wrong thing, the machine will not
Something is getting
understand.
Cutting off.
That will be just a slashed off. So you just we'll take up the matter on some other day. You just remove your defect.
Sir, there are one defect only left out, which could not be rectified because the defects are pointed out in respect to the margins.
Correct, it's right.
Other defects are removed, I have removed.
So now 92 is secured.
9.
92,
Huh.
margin on top of that, we cannot remove unless you buy for another.
You file the copy of this petition with proper margin. We are accepting this, but you file a proper application, then those documents will be scanned. Okay, just you come to your miscellaneous application seeking condonation of delay. There is IA number 2136.
That is.
Press your application for condonation of delay, yes.
17 days of delay.
17.
No, it is 38 days delay. It is 38 days delay.
Lord, order was passed on 29/4/22.
All right, I am giving this order
That
was
is-
passed
that
on
is because
29th
summer
April
vacation was going. That is-
2022.
Lord,
You are
that-
supposed to file the appeal on 7/7/2022. And you have not filed. You filed on the 69th day. You are entitled to limitation of 30 days. And for certified copy, you wasted 1 day. So the 31 minus 69 comes to 38 days.
That was vacation, summer vacation was continuing. That was-
Whatever, but you have to say the correct days of delay. Anyway, I think you will not oppose it.
Just a minute, there is something wrong here. He's filed it on. He's filed it on 27. So they're saying valid presentation is 7/7. Oh,
No, 29/4,
no, 29/4 is the judgment. He has filed it on
27/6.
27th, but they are taking it as valid presentation because certified copy had not
Oh,
been
that is
filed.
correct. They are correct in that way.
One case.
I think you will not oppose it.
No.
Very good.
Actually, the limitation is now being counted on the date of filing of the certified copy.
No, in
That
some
is-
cases we have allowed, we have taken on date of filing. Anyway,
It is- You are Mr. Behra
Mr. Mishra. Yes,
or Mr. B.S. Mishra? Or counsel appearing for the applicant. It is IA number 2136 of 2022. This is an application for condoning the delay according to the stamp reporter, the delay is 38 days. Stop. Since Mr. D.K. Mohanty Learned Counsel appears in Webb's notice, no formal notice is, since Mr. D.K. Mohanty, Learned Additional Government Advocate, appears for the opposite parties and submits that the opposite parties will not oppose the prayer of
My lord, there is a private respondent. There is a
Private
pri-
respondent is there. Then the notice shall go, Mr. Just to have issue notice as to why such and such, just comment. The said delay shall not be condoned or any other order or orders shall not be passed as deemed fit and proper in the circumstances of the case. Notice is made returnable on 4th September 2023. Since Mr. D.K. Mohanty, learned additional government advocate, appears and waives notice for the opposite parties number 2 and 3. No formal notice in respect of those opposite parties is called for. However, the applicant shall take steps for service of notice on the opposite party number 1 within 3 days from today. Stop. In the first, I have stated the appellant. You just got is an applicant. Yes.
20,
In 20, requisites has been filed in late. Notice could not be issued, my lord, because the requisition was not filed in time. That has been filed in late, my lord. That may be utilized.
How late?
It was filed on 28/7/2023.
You're supposed to file within 3 days.
28/7.
So what do you suggest? We'll vacate your interim order.
My lord,
We'll vacate your interim order.
my lord.
We'll be vacating your
Yes,
interim.
yes, my lord. That is my fault because that has been requisites.
So therefore you take steps, but we are vacating the interim order.
So that may not be extended.
No, I will vacate because after 3 months you're taking
That-
advantage.
I admit, my lord, that is my fault, my lord. I admit.
So after that you can renew that if you require so.
Well,
Mr. M.K. Khantial, an additional government advocate appearing for the applicant. That is in I number 1402. Has stated that on 28/7,
yes, my lord.
the applicant has taken steps for service of notice. On the opposite parties. Stop. This is directed to issue notice. Notice is made returnable on 4th September 2023.
My lord.
No, because we are issuing notice that we are issuing notice on the IA. Stop as the stop on 27 they file the requisites. So the registry shall now issue the notice to the opposite parties. Huh? This is several opposite party. Stop. The interim order passed in right here, this I number 1403 of 2023. As the applicant in I number 1402 of 2003 applicants have failed to file the requisites in time. We vacate the interim order that was passed on 21/4/2023 with liberty reserved to the applicant of applicant to renew the prayer by filing a fresh petition.
My lord.
Accordingly, this petition stands disposed of.
21,
Item 21, my lord. My lord, the noting says that there's a delay, but my lord, there is actually no delay. If your lordships may see the last page of the certified copy, we obtained the certified copy on 29/3/2023. And
Just a minute,
as
let us check it. Have you filed the last page of the certified copy?
yes, my lord, the last the
Yes,
certified copy, the back page of the
date of application is, it is interpolated. What is the date? Give the
20
records.
28/2, the date of the order is 22/2. The date of application for certified copy is 28/2.
And date of the ready? Certificate copy was ready on 29/3/2023.
I filed the application on 17/4.
Date of application. This is not the, where the certificate copy.
Certified copy is annexure. Annexure 6. Annexure 6 is the impugned order.
Yes, ma'am.
Yes, annexure.
Annexure 6,
Page 56.
56, 59.
After that. Behind. What is this? That has been smudged and whitener applied. This actually what is it? This is different thing. This is different thing. So the day delivery somebody else has given. Somebody else has given. Okay, ready on 29th.
There is not the issue on the application.
The application was made.
Do you have any document relating to the filing of application?
It is here. I'm noting on.
No, my lord.
According to you, it is 28/2.
28/2.
How do you come to this? How you say that 28/2 file the application?
My
So we
lord,
are showing the certified copy that you filed.
in the last
Just 1 minute. That
the
is
back
washed off.
page. Yes, my lord.
And a whitener has been put. Repeat something.
What will do in the application?
Certified copy filed as an application.
Lord,
You might be having a Xerox copy, just check. Because this could be because of moisture.
Lord,
Read
actually,
percent
I
are there.
don't have the Xerox copy.
Sorry?
Just a minute.
Checking. Read percent are there, 8711 of 2012. Code PN पड़ जाऊँ हमारा code PN पड़ गले. They're all disappearing. I don't know where they go.
Have you just removed the defects in terms of the order dated 26/4/2023?
Other defects.
Other defects.
My lord, I'll remove.
Let the matter be listed on 18th August 2023. In the meanwhile, petitioner shall remove the defects. You are Mr.
Omkar Panda.
Mr. Omkar Panda. You are not on record. Are you on record?
I have filed. My name is there in the Wakalat.
Mr. Omkar Panda and counsel appears for the appellant, and Mr. D. Mohanty, learned counsel, appears for the opposite party's number.
Respondent number.
The respondent number 2.
2.
Stuff on advance notice. Already you just removed the defect on 18th. Because delay is very short, I think you will get the benefit of that.
No, I think if we calculate of whatever date, month is clear. So 28, whatever we find, I think you can calculate and you'll get it. If it is January.
No, he will get it, but remove the defects.
Other defects are there?
My lord, I will file an IA for condonation of delay.
No, if you think so, because even if we take this as the last date will be 28. So from that, if you calculate and show us, we can see. How many days you are getting for certified copy?
We are not asking you right now. After 18th, we'll see.
Okay, madam.
But as an abundant caution, if you want to file, you can file also. You can file also.
Certified copy, they have given you 3 days. You are saying how many days?
30 days.
30 days for certified copy?
28 to 23 to 29/3/2023.
Okay, we check up, next date we'll see.
22.
Item note 22, my lord. Today file one limitation petition, stay petition. We need 7 days time for removal of defect, my lord.
Your name is?
Maheshwar Jati.
The request of Mr. M. Jati, learned counsel appearing for the appellant, let the matter be listed on 25th of August 2023. In the meanwhile,
Copy may be solved on us because copy
in
has.
the meanwhile, defects as identified by the registry shall be removed. Mr. D.K. Mohanty, learned counsel appearing for the opposite parties. No, respondents, sorry, has pointed out that no copy of the memorandum of appeal
In course of the day.
has been supplied to them. The Mr. Jati is directed to supply a copy of the memorandum of appeal in the course of the day.
In course of the day.
Yes.
Oblige, my lord.
23.
23. Petitioner was supposed to appear in person.
They're online.
That appears for the petition when the matter is taken up. Let the matter be listed on 4th September 2023. You appear in this matter, Mr. Mohanty.
No, I don't know whether government is a party because we have no record with us. He has not served any read copy to us.
Government is also party anyway. Let the petitioner come.
24.
24 also no read copy has not been served. Read appeal.
So there is a
Yes.
delay, my lord.
4th September. You are Mr. Shetty
My lord.
in IA 3888 of 2023. Heard Mr. Dharmendra Sethi, learned counsel appearing to the applicant. There's an application for continuation of delay. According to the stamp reporting, the delay is 538 days in filing the appeal, inter-court appeal from the order dated 15/12/2021, passed by the learned single judge in WPC number 24553 of 2019. Issue notice as to why the aforementioned delay shall not be condoned or any other order or orders shall not be passed in the circumstances of the case. Notice is made returnable on 4th September 2023. Steps for service of notice on the opposite parties. Number 3, 4, 5, and 6 shall be taken by the applicant within 3 days from today by registered post to AD. Since Mr. D.K. Mohanty, learned regional government advocate, appears in web's notice for the opposite party, respondent
number
number,
one and
opposite
two.
parties number 1 and 2, no formal notice is called for in respect
Copy may
of
be
those.
served.
A copy of this interlocutory application and the memorandum of appeal be served on Mr. Mohanty and additional government advocate in the course of the day. Other you take steps and serve a copy on him.
Yes, yes, my lord.
4th September, huh? First of in view of the above arrangement as reflected above, the defect number for. No, he has not received copy, he'll give. You supply in the course of the day, and in view of the arrangement that has been reflected above, the defect number 5 stands addressed.
25.
5D.
5D.
Hello, I have in BC. Item 25, 26 and 27. So Lordship may grant me 7 days time to remove all the defects. And Mr. Buddhist.
Yes. Mr. Das, are you appearing for the appellant?
Yes, my lord. I am for the appellant.
Please unmute yourself.
Pardon?
Unmute yourself, Mr. Das.
Yes, my lord. Am I audible, my
We
lord?
can't hear. Yes. Yes.
Yes. My lord, 25, 26 and 27. So Lordship may grant me 7 days time to remove all the defects.
29?
25, 26 and 27.
No, 25 is copy not served.
Copy. My lord, government is not.
25, 26, which is the cases?
It's a Tata Power matter.
Just see the, huh?
Other side was appeared. SR could not be made for non-marking of page. Okay, let them remove.
The request to Mr. B. Das, Learned Counsel, appearing for the appellant. Let the matter be listed on 29th August 2023. In the meanwhile, the defects as identified by the registry shall be removed. All the 3 cases, same order, huh?
My lord, I have another request, my lord. The name item 25 Buddhist Kumar Behera is shown in the column of the advocate. He is not an advocate. He is an officer of Tata Power. But I don't know how it is reflected.
All the registry is directed to.
First.
Yes. His name may be
First case, that not to reflect the name of Mr.
Might have
Buddhist Kumar Behera.
This.
Where is it is there?
That is there in the first page of the brief.
Inadvertently, it has been reflected.
Not to.
Delete the name.
Where is this?
It is there in the first page of the brief. Top.
Buddhist Kumar Behera?
Yes, it may be deleted.
Not to delete the name of Mr. Buddhist Kumar Behera from the records, as he is not a counsel for the appellant. Yes.
28.
These 3 matters were there, your lordship, the other day. That interim prayer was to be considered. Panchayat matters, my lord. So your lordship had asked me to take instruction whether my financial power, the Sarpanch's financial power should be squeezed and given to Gram Panchayat extension officer or not. That is what your lordship has suggested.
Yes.
That can be done, my lord, because in first case it is regarding ward member. So he doesn't hold any financial power. In other 2, 1685 and 1686, they are Sarpanch of respective panchayats. So there your lordship may stay subject. Gram Panchayat extension officer may be given this financial power.
All these 3 matters have been listed in orders. Since certified copy of the impugned orders have not been filed. That is the noting.
Yes.
And in fact, I found out one judgment. Well, there he was removed from the office. Thereafter, since ultimately Honorable Single Judge allowed the writ petition, thereafter charge was handed over. I have got one citation.
So is he already handed over?
No. In another case, reported judgment, well, he was disqualified and removed from the office. Since he succeeded in the writ petition for the Honorable Single Judge ultimately directed he should be handed over the charge.
Yes,
So this can be done here.
No, I could not get you. Actually, is a measure of interim order that the other person who was given charge of the handling the finance of the panchayat after the disqualification proceeding.
After the disqualification proceeding, though I was allowed to continue as the Sarpanch, well, but the financial power was withdrawn.
Okay, you want the similar order to be passed?
Financial power may be given to my lord, the district panchayat extension officer. I have got no quarrel over that.
So this order can be passed according to you. But you have not filed the certified copy.
Certified copy also downloaded copy I had filed, xerox copy. Today,
Downloaded copy is not certified copy, Learned Counsel.
today I am filing it, your lordship. It is there. I am filing it now.
Then it will go for the reporting. It will let the matter be listed again on
Tomorrow, your lordship.
tomorrow, day after tomorrow. Let it
Thursday.
come day after tomorrow
This
because
has been initiated at the instance of a private party.
already we are not passing any effective order today. Mr. S.S. Sarangil and his senior counsel has submitted that the appellant has filed the certified copy of the impugned order in the proceeding today. Let the said certified copy be taken on record. Registry is directed to carry
All
out
the
the
cases?
stamp reporting and list the matter on 3rd August 2023. Mr. P.K. Muduli, an additional government advocate, has appeared for the official response.
Lords,
Stamp okay.
Is
may I pardon to mention, my lords?
just a minute.
Yes.
In all the matters, the similar situation, you are filing it, okay. All the appeals from it, there is a written petition, no order.
Last three matters, your lordship.
Right.
Writ appeals.
What is your prayer?
Item 29, my lords. Just, sir.
It is came. It is.
Lordship, here is a case, my lords. I have provided all the benefit to the land trustee, like employment, compensations, and quarters for the temporary accommodation.
You are appearing for the Mahanadi Coalfields
Yes.
Limited.
Yes. Lordship, may not be possible today, I think so. Lords. Tomorrow, my lordship, may be taken up.
Yeah.
We do not look, come at 2, let us see. At 2 you come again. Let us see what happens.
Who is that other bench?
Oh, Acha, this
There
bench
is a
is there.
division bench, my lords. That's why I am saying.
That is the figure.
Tomorrow, my lords.
Day after tomorrow. This is relating to the compensation. Day after tomorrow.
Pardon
Yes.
to make a mention of item number 38, my lords. In the last doc, my lordship has fixed this matter specifically today, my lords, to file and write him to file the objection to the IA, my lords. I am filing the objection as well as a short count.
Why are you filing in the court?
My lords, because there is a stipulation that no further accommodation will be made for the said purpose.
That is why did you not file it earlier? That is what we are saying. Why are you filing it in court?
I think I'll file it before the registry.
All right, take it on record. List the matter on 3rd August. All right, come on 3rd August.
Grateful, much.
My lord, may I beg pardon?
In that case, interim order to continue.
Interim order is passed earlier, shall continue till the next date.
Yes.
My lord, may I beg pardon to mention item 44. There is a stay order here, and I am for the respondent. I pray for a short time. I have appeared so much.
Mr. Kuntia, we are on fixing the matter on 30th of August.
My lord.
Delay shall be condoned. He's appeared.
No, he will file any objection against the condonation.
My lord, I have not received any copy.
All right,
I have
all right,
appeared
Mr.
so much.
Kuntia, supply the papers.
Yes, I will supply in course of the day.
All right. Your good name, sir?
Mr.
Saratchandra
Kuntia,
Samal.
requisites you have not
Saratchandra
filed, so
Samal.
serve to him.
I am in course of the day.
Take a receipt.
Counsel has appeared for the sole respondent, Sharat Chandra Samal, for the respondent. And at the request of Mr. Sharat Chandra Samal and counsel, for the respondent, let the matter be listed on 30th of August is a Saturday. 30th.
So you have been vacated.
My lord.
My lord, item,
I may
pardon, my lord. My lord, item 50, my lord.
Mr. M.K. Kuntia, learned additional government advocate, request to supply the copy of the memorandum of appeal to Mr. Samal in the course of the day.
In course of the day.
And IA also.
Interim order is passed earlier, shall continue till the next
45
date.
interim order to continue.
41, my lords.
45.
Memorandum can
of
go to
appeal
same
along
date.
with the condonation petition.
My lord, item 50, I am the petitioner, my lord, conduct the case in person. Item 50,
55.
my lord, 50.
Ah.
My lord, I am the Jagannath Bastia, WPC number 23988, my lord.
50.
Item 50, my lord.
55, yes.
WPC number.
Two matters are there.
Five-
There's no time today. We have to fix another date.
Item?
50. This is the
50.
second petition is there. That one.
You are Mr. Jagannath Basti.
Yes, my lord.
So you're fixing the matter on 14th of August? Try to.
14th of August at 2 p.m. At 2
Lot of
p.m.
matters, yes.
What matters then thereafter?
30th of August.
Yes, my lord, in this case, the honorable court has the last time directed the government advocate to file, given last opportunity to file the reply in my amendment in this case.
No, he did not file.
My lord, I'm just submitting. There are two writ petitions. Similar prayers, same subject matter. In the Sambit Patra case, one is filed by Dr. Sambit Patra. In that case, there is comprehensive pleadings and all the prayers are in. In this
You
case,
just file a one-page application that we adopt it and we'll accept that.
no, same prayer, same and both the cases are
And
tagged.
Mr. Mohanty, you
Yes,
are very techno-savvy, I am told. Then if it is the same thing, you have to just take out a printout and file it there.
To my lord, my prayer and my update all the.
No. What he is submitting on the basis of that, I am making this remand. He says it's
Yes, I
exactly
will,
the same.
before that date, I will.
He wants an
Not before that
objection to
date.
his amendment petition. He wants an.
Not before that date.
That
You have to
amendment
file
is a
before
formal, because
20th of.
even if it is allowed, that will
21st of
cover
August.
the original writ petition.
To my lord,
Same.
my lord, for proper adjudication of my case, I have filed the amendment petition and the honorable court given a last opportunity to the state government to file the reply. Last opportunity. Government, the honorable court has
objection,
already
we allow the
given
amendment.
sufficient opportunity and several
Not
directions.
allowed,
My lord, my lord. I pray once again, my lord, kindly direct the state government to file the counter in my amendment
Just
petition.
wait, Mr. Bastia.
1 minute, 1 minute. That is
680. 11968, my lord, of 2020, my lord.
to see what format it is in.
We are allowing this amendment
Yes.
petition.
And we will file some additional counter.
Yes.
Yes,
You have
yes.
not filed the counter. What is the additional counter?
We
No,
have
they have
filed
filed
the
a
counter
counter.
in the original writ petition as well as in this petition.
No,
both the
my
petitions.
So you
No,
got,
my lord, they have not.
He's refusing. He has not filed the counter affidavit and we
Submit
don't file any counter
Submit
affidavit also.
we're giving you a chance, you file a counter
Yes,
affidavit.
No.
Yes.
Counter affidavit filed on behalf of the intervener. I do not know. And then opposite party number 6. You are not opposite party number 6.
No, I'm one.
You are also not opposite party number 7.
Not
They have
8.
filed.
I have to check.
6 and 7 have filed. Then let us check. You are not also opposite party number 5.
Within 10 days, we will file the counter affidavit. He may be directed to file the consolidated writ
Just a minute,
petition.
let me see the petition. What are you representing?
5, 6,
1,
7,
2,
8
3,
have filed.
4. So these 1, 2, 3, 4 are you are represented by you.
But what is,
8, also
just
10.
a minute. Look at this amendment. Amendment is 100 pages. Have you gone through the amendment petition?
Yes, that is a big, I have seen that.
But
the
you are
same
not saying that. You are saying amendment may be allowed.
that only formal amendments and all these allegations are covered in the Sambit Patra case also.
No, that is not the point. If you have no objection, we can allow the amendment, but we are
Not to
just
fix it, I will
noticing
file a
100
formal
pages
objection
amendment.
there.
It's all right.
I will file a formal objection.
No, why should you file? If there is no problem, if he amends it, why should you file?
I
Let
think
it be.
if you have not filed the reply, we allow the amendment petition, you file the reply against
You
all.
file the counter.
the
Yes,
original writ.
that will be
All
better.
right.
That is better.
This is a miss case number 1, a miss I number 11968/2020.
Second case type.
Heard Mr. Jagannath Bastia in person. This is an application seeking amendment of the writ petition he has filed, being WPC number 23988 of 2019. Stop. The opportunity was granted to the opposite parties to file the objection, but no such objection has been filed as yet. We have perused the proposed amendment as provided under the schedule appended to this application. We do not find any impediment in allowing these allowing the petitioner to amend his petition in terms of the said schedule. Stop. Accordingly, this amended petition stand allowed. The applicant, within bracket, the writ petitioner, is directed to file consolidated amended writ petition within a period of 15 days from today. Stop.
Serving copy.
Serving copy of the consolidated reputations to all the opposite parties. Stop. After serving copies, stop. In view of the above, this application stands allowed and disposed of. Then we go to the writ petition. In view
Liberty
of
may
the
be
order
given to
passed
us.
today, in I number such and such, the opposite parties number 1 to 4. The opposite 1 to 4 and 10, I think. Now they just speak for them.
All the opposite parties can be permitted to file counter affidavit.
Some of them is fine.
No, they'll file additional. So that's
Opposite parties number 1 to 4 and 10.
Pardon, my lord.
Just a minute. The opposite party number 1 to 4 and 10 may file the counter affidavit by the next date. We're fixing 4th September. 15. You file this consolidated. Consolidated means incorporate.
Earlier
all
you
the
had said you will
amendments.
adopt, but
file a total
now
of
you are
15
giving
additional
another chance.
because the court also
Because I have to
supplying
reply
copy.
the new amendments in the amendment.
September, the other date gave September, 12th of September.
You
My
check
lord,
and see.
4th of September is over.
4th of September.
4th of September at 2 p.m. Because
4th of
it is
September,
not.
let the matter be listed on that day at 2 p.m. The other opposite parties who have already filed their counter affidavit, they are also permitted to file the additional counter affidavit,
So advise.
restricting the same only on the amended part of the writ petition. Stop. As well as those opposite parties who did not file the counter affidavit as yet, they may also file their counter affidavit by 4th September 2023. What is your prayer?
My lord, I am appearing for the temple management. Jagannath temple management.
We have allowed their amendment petition, so they will file now a consolidated petition, and we have granting. If you have already filed, you have filed already a counter affidavit.
Yes, my lord.
You may file an additional counter affidavit on the amended part of the writ petition, and those other opposite parties who did not file the counter affidavit as yet, they may also file the counter affidavit. Oh, this 15 days, I have stated. No, he says the 4th of September, they will file. Let's see. Because they must get also.
This is not. This is on 4th September. We say again every day.
Why don't you file the counter affidavit by 30th of August?
I will file.
30th, that is better.
Before 30th of August, I will file. Once I receive the consolidated, within 10 days, I will file
all the parties. Counter affidavit / additional counter.
He will file by 14th. So
No, because he may file by the 15th.
so you have 15 days.
15 days, more than sufficient.
Yes.
All right. But how can you say the more than sufficient? The writ petition was filed in 2019, you have not filed. And now you are saying it is more than sufficient.
Because what I
what I understood,
the
he
other case
understood.
is more important. This case
He
is
understood
covered with
that you are overburdened.
There will be a consolidated hearing.
Okay. Same
That
thing already
other
there.
case is more important, where Mr. Pitambar Acharya
No,
is
now
appealing.
you have to just respond to these new facts they have brought by your amendment.
Those facts are covered in the other case also, and we have replied.
Alright.
These are
We have
two
the
club
order passed in the
matters.
first case, passed in WPC number 23988 of 2019. Let this matter be listed on the same date. But none appeared for the petitioner when the matter is taken up by us.
Other matter, no?
Other matter, Sambit Patri.
But Mr. Omkar.
No, he is for the temple.
He is for the
opposite
temple administration.
party.
On behalf of Mr. S.P. Mishra Senior.
Huh?
My lord, on behalf of Mr. S.P. Mishra Senior Advocate,
Already.
my power is also there.
And Mr. Omkar Panda, Learned Counsel, your power is also there.
Yes, my lord.
Then no
That is
problem.
why on behalf of Mr. Mishra?
Omkar.
How does it, what does it mean?
My lord, he has been appointed as a special.
That's all right, but
That's all
your
right,
power
but
is
as a
not there.
council, you are appearing for only for the temple committee.
Yes, ma'am.
Power is not there.
His name is there. The causeless just check up. That is why.
So cause list I can't find. Jagannath first here. Pranayama.
Item number 1.
Hmm?
Item number 1.
Okay.
You are appearing for two, Sri Jagannath Temple Managing
Yes,
Committee.
manage.
Appears for the two, and Mr.
First matter re OP2.
D.K. Mohanty, Learned Additional Government Advocate, appears for the opposite party number 1, 3, 4, 5, 6,
8, 7.
7, and 7. 7, 9, 10, 12, 13. And 13, okay? So all the government authorities you are appearing for.
Yes,
them.
I am for state of
There's no
functionaries.
representation for the remaining opposite parties.
The Lordship has indicated
Okay.
at 2 p.m. it will be taken.
And Mr. Bastia, that they will file by the 30th of August, the reply. If you intend to file any rejoinder, be quick and file before the next date. We are not reflecting.
My lord, I pray, my lord, kindly grant status quo over the land. Till disposal of the
That
case.
prayer has been terminated.
No, this will not
Since
do. It will only add to the complications. That will not do.
Item
Because we don't know what is the status. We pass a status quo order. Some people unauthorizedly occupying some place and they will be regularized by that order. That will
Because
not
my
pass.
lord, when the matter is subject before this honorable court.
No, make a survey report
before.
before us. Who is what in what position? Then we'll pass the order. We find that they're all right. Because otherwise, some stranger inside it and they will be regularized by the status quo order. That will not pass. Okay. Now call the next item.
My lord, at 2 p.m. My lord has indicated it at 2 p.m.
2 p.m.
Item 41, my lords.
Well, it is a public interest litigation. Pleadings are complete. It relates to an infrastructural development in both towns and it connecting to the national highway. And I have an intervener whose land is being sought to be possessed by the government for construction of the road. I intend to give the land. I will given my consent. Still,
this cannot be the matters of the public interest litigation.
Private
It's
land
it
is
a
being
private
given.
interest litigation.
No, it is for
So
construction
today
of
we
the road.
cannot, however, we cannot take up the matter. We are fixing the matter some other day.
May I
28th of
play-
August.
No, why the urgency? Because that road is a development and linking to the national highway. It
Is there
prevent
any
a lot
stay
of
order?
accidents.
Is there any stay order from this court?
My lords,
Any stay order from this
No,
court?
no.
So
We
forget
want the
about it. We are
construction.
fixing a date. When can we fix it? 30th of August. Yes, there is no time today. Let the matter be listed on 30th of August 2023. We'll consider on that day. 30th
Yes,
of August.
I'm appearing in that case.
Yes. You are Mr. Tripathi.
no, my lords. I am Abhijit Pal. I am for the intervener.
Oh, you are for the intervener. There is a Mr. None appears for the petitioner when the matter is taken up. However, Mr. Mohanty, you are appearing for whom?
For the collector. Opposite partner one.
But Mr. D.K. Mohanty, Learned Additional Government Advocate, appears for the opposite parties number 1, 2, and 3. You are appearing for Miss Sabita Agarwal
Yes, ma'am.
and Mr. Your good name?
Abhijit Pal.
Mr. Abhijit Pal.
That means you and the petitioner are sailing in the same boat. They
Yes.
want upgradation, you are supporting it. Only the government is delaying.
Yes. Even they have already exempted the registration.
Appears on behalf of the opposite party number 4. You are not intervener. You are the opposite party number 4. You are already added as a party.
Yes, I have already been added. After I intervened and
No longer an intervener.
yes.
All right.
Opposite party number 4.
Other matters, the date will be given.
Wait, please.
Yes, but I had on the last date taken a losses through Sangyong and highlighted the principles, my lord, that losses have evolved when it comes to, my lord, adjudicating a section 34 or, my lord, a much narrower 37. Why I say much narrower? Because, my lord, losses have held that 37 is much narrower than 34. And that's the consistent jurisprudence, my lord, on that. Then I had taken a losses, my lord, on the issue of waiver and estoppel and shown as to how it was in the pleadings, how it was put into evidence, and therefore it was a matter of trial before the arbitral tribunal. It was tried by the arbitral tribunal. There was evidence, there was cross-examination. And then, my lord, the tribunal goes into the question, poses to itself the question with respect to 2010 series and comes to a conclusion that I have not been able to make out a case of an estoppel using the 2010 series or a waiver using the 2010 series. However, when it comes to 2012 series, the tribunal makes out from the evidence a conclusion that 2012 proves a waiver on the part of the respondent. Now, my lord, I had then, my lord, concluded by taking rushes to para 238 at page 1546 of the award. May I pick up the threads from there and then go on? Kindly come to, my lord, 238. And pardon me for not taking a short step back. Since your lordships are on 238, could I invite your lordships' attention to 234 so that I'm able to correlate?
Page.
That will be 1545, volume 3. My lords have that now?
Yes.
I'm so deeply obliged. I'm inviting your lordship's attention back to 234 for a reason. The reason is, what was the case of, my lord, the respondent before the tribunal? Let's see that now from 234. The respondent challenged the sufficiency of the evidence advanced in support of a case for waiver or an estoppel. Respondent also relied on the terms of a no oral modification clause found in section 25.5.3 of the amended CWEETC agreement, which provided as follows. So two arguments, my lord. One, that the evidence before the tribunal was insufficient to conclude a waiver. And two, that waiver would be incompatible with section 25.5.3, which is a no modification clause. In the light of this argument of, my lord, the respondent, the tribunal, my lord, refers to rock advertising, and that is in 235. I can skip, with lordship's permission, Lord, I can skip reading 235 and then, Lord, kindly now come to 238 in this slide at 1546.
Yes. The tribunal finds that.
May I place that again, my lord? In my respectful submission, a paragraph of some significance on this point, my lord, that shows examination of facts, examination of evidence, appreciation of evidence and its application, and coming to a reasoned conclusion by the arbitral tribunal. The tribunal finds that an equitable estoppel arose in March 2012 because the respondent, by its words in the email dated 18th March 2012, having regard to the context in which it was sent, expressly and by its conduct, represented that the formal notice provisions in the agreements were not and would not be strictly relied on by it, and encouraged and invited the claimant to adopt the same cooperative approach and to not issue formal notices of claims. The tribunal is satisfied that the claimant has thereafter, to the knowledge of the respondent, acted to its detriment by relying on the representation and respondent's conduct by not issuing formal notices. I'll pause here for a moment. my lord, there is an argument made before your lordship, my lord, by the appellant that this is not factually correct. In fact, the claimant did issue 3 notices subsequently, and those 3 notices, therefore, are in the face of this conclusion of the tribunal that no formal notices were issued by the claimant. Now, my lord, I do not wish to go back, my lord, to the argument of this aspect of the matter being completely outside the purview of 34, or for that matter, my lord, 37. That remains my first argument. That this is, my lord, this inquiry into facts and inviting the court, my lord. And therefore, I gave that analogy, my lord, of the emperor and 2 soothsayers. How one puts it, my lord, makes all the difference. But what the court, my lord, looks at is the substance of the argument, not the form. I, as a soothsayer, may tell you, no, it's perfect, it's great. But your lordships would look through that form and look at the substance of what I am trying to say. In substance, whether I am trying to invite the court into a factual inquiry, into an evidential inquiry, or in substance, I am trying to say, well, this is not something that the court ought to, my lord, go into in view of, my lord, the fact that we have adopted the ancestral model law and all those provisions. So, coming back, my lord, to this particular paragraph 238, argument is made that 3 notices were issued. I have that part in my submissions. I will come to that a little later and I will answer that. But please note that none of those 3 notices, if I were to answer factually, but lordships are not the arbitral tribunal, nor are lordships can be called upon, my lord, to adjudicate. But nevertheless, to satisfy, not to answer an argument, none of those 3 notices, and I am going to show those 3, my lord, none of those 3 notices were notices of claims. And the tribunal examines those notices, some of them. Now, my lord, please may I go further? An estoppel arises because there is evidence of reliance by inference drawn from the terms of the claimant's reply email dated 29th March 2012, emphasized above from the.
Can you just, what is the exhibit mark of these 3 notices? Can you just.
But when I come to those 3, I will take your lordships through that, please. I don't remember the exhibit, but we can check up what is the exhibit mark. No, that's what exhibit mark is what. We'll come to that. I'll give the reference and I'll deal with those. But please take it not that those are not notices of claim, but I'll answer that. May I continue not reading? 238. An estoppel arises because there is evidence of reliance by inference drawn from the terms of the claimant's reply, email dated 29th March 2012, emphasized above. The second piece of evidence. From the evidence of Mr. Zhu in relation to his earlier discussion with Mr. Rao, second piece of evidence. Third piece of evidence. And from the reaffirmation at the November 2012 Jinan meeting, it would be unjust and inequitable, having regard to all the circumstances, including the inconsistency arising out of the benefits obtained by the respondent in the CERC proceedings, to allow, that is not the 4th piece of evidence, the CERC proceedings, because they have taken the benefit. And I'm going to very briefly not refer to the CERC order also. To allow the respondent to deny a claim because the claimant, to the knowledge of the respondent, followed a cooperative approach as a result of the respondent's invitation to the claimant to do so in March 2012. But may I put myself, my lord, a question? Suppose, my lord, in a domestic award where the inquiry is much larger, a domestic tribunal comes to this conclusion, and this conclusion is questioned by, my lord, a challenger, by a petitioner under section 34. Would not, with utmost respect, my lord, that petitioner be told that these are conclusions of facts, these are conclusions derived on the basis of appreciation of evidence, and therefore it is not possible for a 34 court to enter into a domain of, my lord, a factual dispute or a factual issue. And therefore, my lord, with greater respect, I submit, my lord, that in case of an international commercial award, and assume for a minute with me that the conclusions are wrong. Assume for a minute with me that the conclusions are wrong.
Yes, yes, just please continue.
Not even then, your lordships cannot be called upon by a petitioner to say, please look at these emails, please look at these letters. Do you as a court conclude an estoppel or not? That with utmost respect would be a complete violence, if I may say so. With utmost respect, I submit. But we have violence, my lord, to the statute. Now, my lord, 2 or 3 aspects are clear from 238. 1, the tribunal says, you have taken a benefit of this particular conduct of the claimant, which is at your instance for a cooperative approach. And you have taken the benefit in the CERC order. Now, what CERC order was before the tribunal and is also before your lordships. May I very, very quickly refer you to that?
Which one you have? The note?
It's there in the note also. We have referred to it now. If your lordships want to turn to, my lord, paragraph 27.7 at page 9, internal page 9 of our note. My lord, page 9.
GKEL stands before. That's paragraph.
Your lordships speak a little louder, my lord.
I'm thinking GKEL stands before. That's paragraph starts.
That's correct. GKEL stands before the CERC. I am so deeply obliged. May I read that paragraph, because my friend has not laboriously not put it all together and put it here, my lord. And we can also refer to the CERC judgment if required. In certain CERC proceedings for determination of generation tariff for Kamalanga power plant against Gridco from 1/4/2013 to 31/3/20, it should be not 1/4/12. Just correct it. There's a typographical error on our part. I kindly pardon us for it. 1/4/12 to 31/3/13. As my lords note, not the Electricity Regulatory Commission fixes the tariff not for a financial year. The appellant obtained a financial benefit by claiming delays in relation to the same project, including delay in handover of land, delay in grid synchronization, and change of law. SEPCO submitted that it would be highly inequitable for GKEL to claim financial benefits in relation to the same project, in relation to the same subject matter before the CERC, but to deny the same to SEPCO, who had suffered on account of the same delays. The AT considered this and held that it would be unjust. Not I have read that, my lords. The second sentence is important. Reference may also be made to SEPCO's reply post-hearing submissions on main claims and CERC's judgment dated 12/11/2015. This is on record as Annexure 86, Volume 15, page 6927. If lordships want, I can take lordships through this. But all that it does, is note submissions made on behalf of GKEL and allow some of those factors to say, well, this will be factored into as a delay, and on that basis, certain cost benefits have been granted to GKEL. So the tribunal, concludes that having yourself taken advantage, you know what the delays are, having yourself taken advantage of those delays and obtain a financial benefit, can you turn around and say, well, I can obtain the benefit for delays for which SEPCO has not made a formal notice at my instance, but SEPCO is not entitled to the benefit of those delays. The tribunal finds it inequitable. Now, I ask myself, is this conclusion of inequitable conduct unknown to the contract law? Because that was the argument made, that how is it that there is a clause in the contract which says there can be no oral modification, and in the face of that contract, can you come to a conclusion that there is a waiver? The tribunal employs a reasoning to come to that conclusion. Tribunal says, in terms of rock advertise, if there is evidence of written exchange between the parties, which gives an impression that the parties have agreed to waive, nothing stops the parties to adopt that conduct. Nothing stops the parties to adopt that conduct. You just read a contract in a commercial way, how the parties have acted on it. Not bereft of it's not a statute plot. Lordships have repeatedly emphasized that a contract is not an edict of the legislature. It is to be read not like a statute. It is not to be read like a statute. It is to be read like a contractual, a commercial document between the parties. How did the parties understand it? This is a huge project. How are the parties going about it? Not it has a life of its own. The contract has a life of its own. The parties have, my lord, therefore agreed. Now, to emphasize that, because, my lord, much labor was placed on this argument of 23.3, no role modification. But please kindly go back to what GKEL's own case was before, my lord, the tribunal, and please have the award with me once again. Kindly come to page 1513.
Same volume?
Same volume, volume 3.
Volume 3.
1513.
1513, my lord. My lords have noticed from para 238 of the award that the tribunal also refers to November 2012 agreement. Now I am showing you, lordships, not what is the conclusion of the tribunal on November 2012 agreement. And what was the respective cases of the parties. Please kindly come to Murad 102, paragraph 102. My lords would find just above 102 a heading called November 2012 Jinan Agreement. My lords, see that one?
Yes.
Between 2 and 7 November 2012, following numerous delay events with respect to the project, the parties met in Jinan City, China. On the final day of the meeting, the parties agreed and signed minutes of the meeting. The Jinan Agreement contains the following relevant provisions. Now, why am I reading this to my lords? To contextualize as to how the tribunal deploys, my lord, the reasoning in rock advertising. Takes this into consideration as a written exchange between the parties, one of them, to, my lord, waive the formal notice requirement. Now, please have, my lord, these minutes set out in 103. The Jinan Agreement contains the following relevant provisions. On detailed deliberation, following are the key decisions and resolutions arrived at during the meeting. Parties agree that there has been a substantial delay in achievement of the milestone dates related to the project. Hence, following recovery schedule has been proposed by SEPCO to arrest any further delay. Then there are dates set out. After the table below, SEPCO has requested that the milestone dates under the offshore supply agreement, the onshore supply agreement, and the agreement for civil works and engineering, erection, testing, and commissioning, that is not CWEETC, that's the third agreement, shall be replaced by these new dates as stated in serial number 1 above. So what SEPCO says, please incorporate these dates in the agreements, in the offshore supply agreement, onshore supply agreement, and in CWEETC. Please incorporate these dates. What does GKEL say? Next paragraph. GKEL has agreed to the request of SEPCO and has also stated that any amendment, now please mark this point, any amendment to the agreement at this stage is not possible, as it requires long process approval from lenders and other stakeholders. The parties shall finalize such change or amendment after completing successful completion of reliability run of the unit number 2 by 30th of June 2013, as lender and other stakeholders shall expect to demonstrate completion of the project before seeking any change to the existing agreements. On the basis of these minutes, certain arguments are made before the tribunal, which are set out from 105 for the claimant. What was the claimant position? Please turn over the page. Please see what was the respondent's position. Kindly come to para 110. But the respondent's position was that November 2012 Jinan meeting has reset the dates for completion. Claimant's position was that the respondent, in agreeing to reset those dates, has agreed also to compensate the claimant for the delay. Respondent said, well, I have agreed to resetting of the dates, but I haven't agreed to compensate you for that. For that, you have to establish your claim. But what is important is both parties agreed that November 2012 had informally, if I may use the term, informally amended the contract by shifting the dates to what was agreed by the parties in November 2012. It was a common position. What was the effect of that agreement? Did it have an impact on the compensation or duty to compensate or right to seek compensation is what now the tribunal examines. Please see, my lord, the tribunal's analysis culminating in paragraph, my lord, 164 at 1526. The claimant argued that once you have agreed to shifting of the dates, then you have to compensate me because you have agreed to shifting of dates. That implies an agreement to compensate. Respondent said, yes, sir, we have agreed to shifting of the dates, but it doesn't imply an agreement to compensate. Parties are at issue. Please see, my lord, 1526, 164. In relation to the questions posed by issue 1, the tribunal finds that the effect of the November 2012 Jinan agreement regarding, now please turn the page over to 1527. The agreed milestone dates for completion of the project was that SEPCO was granted an extension of time pursuant to the terms of the contract, and 2, the original milestone dates were not replaced with the replacement milestone dates. B, SEPCO's claim for time prior to this date was that all such were resolved, but it had no effect on and did not address or resolve SEPCO's claims for money arising prior to this date. It did not give rise to any automatic entitlement to prolongation costs. If the claimant seeks prolongation costs in respect of matters before and after November 2012 Jinan agreement, the claimant is required to establish all of the contractual elements which are required to give rise to an entitlement to prolongation costs, including requisite procedural notices and the reasons for any length of any critical delays. So the tribunal comes to a conclusion that you have shifted the dates, but you will have to prove your entitlement to damages. But the takeaway from this conclusion is that the parties did not make a formal amendment in the agreement, but agreed to shift the milestones which would have the effect of amending the agreement by way of a meeting. It is in this context that this piece of evidence is appreciated by the tribunal in concluding what it does in paragraph 238. Now this poses a question. Having seen this evidence before the tribunal, by the tribunal, and the tribunal forms a view that this amounts to an inconsistent conduct in the sense that you are telling us, you the respondent are telling us that no, there is no question of a waiver. But here is a claimant who has not notified you of these delay events, which according to the claimant entitle the claimant to certain compensation, and which delay events you have taken advantage of in the CERC judgment. The question is, my lord, could this conduct not amount to equitable estoppel, or that in view of 25.5.3 of the contract, equitable estoppel is completely outside the contract. Now, my lord, firstly, this is a question which relates, my lord, to interpretation of a contract. Interpretation may be right, interpretation may be wrong. Even a wrong interpretation by an arbitral tribunal in a domestic abort situation is not capable of remedy or rectified or challenged in a section 34. Where is the question of it being questioned in an international arbitration award law? Besides,
You mean section
even
34, not 24 or 34?
I'm sorry, my lord.
Section 34, that cannot be objected to.
No, my lord. Even in 34, the
Yes.
the judgment say then that even a wrong interpretation of the contract is outside of 30. Even in a domestic abort situation. We have what we have done, my lord, as a part of the note that I will be tendering. We have put together all the ratios of these judgments so that not it is handy and available in one place to my lords. Yes. And that's how the law has evolved, also through 2015 amendment. That there can be no review of facts. Now, my lord, even the Contract Act, we have a codified Contract Act, not the proper law of the contract in this case that lordships are adjudicating was English law. But even under the Contract Act, my lord, principle of estoppel is inbuilt. I'll give a few examples. Kindly take up the Contract Act with me for a moment.
Yes.
Let's kindly come to, and these are only illustrative, not by no means exhaustive. Kindly come to 41. Do we have another copy? Contract Act? You have one? This money doesn't have it. You have another copy, I could have passed it on. You give it to me. Can I pass this on? Doesn't matter, Lord. I have it on a soft copy. It won't be an inconvenience at all. And surely can't be, not while assisting losses, I can. There's no question.
soft copy done, buddy.
Kindly come to 41. If not the performance of a contract is accepted from a third party, then it can't be demanded from the promisor. What is this rule? What I ask myself? The contract is with the promisor. But what is this rule? Is it not a rule of estoppel? You've taken the performance from somebody else. You're now stopped from seeking it from the promisor. 41. Effect of accepting performance from a third. When a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promise. Another example, 63, my lord. Kindly have section 63. Every promisee may dispense with or remit wholly or in part the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it in any satisfaction which he thinks fit. He can waive it. He can have someone else perform. These are all not principles of equity woven into our fabric of not the contract law jurisprudence for a good reason. That a contract law is a living document between two parties. how the parties after entering into a contract conduct themselves is important, not for its construction. But to say having acted so afterwards, you can't now put the clock back. You can't have the fruits, but not have the pains of that particular conduct. So therefore, my lord, the Act recognizes it. And Lord, what are we today, my lord, into? We are looking at a situation where the contract is governed not by the Indian Contract Act, which also allows this to be not before the tribunal, but by the English law. Now, my lord, on this aspect, there are a couple of judgments where I very quickly. Have you got Gemini? No, Gemini first. Let's see. Okay, I'll go ahead. No, I have it. Don't worry. Give me a moment. Give me a moment. I have marked. Give me a moment. Give me a moment. Which para you want me to? No. Let's just review it once. I just want to give the best one. But may I, just Talapatra put a question to me with respect to a wrong interpretation of a contract. I have the judgment ready, but give us a few moments. I will cite it just immediately, but not after a few minutes. May I take your Lordship through a few judgments which deal with the concept of equitable estoppel in the context of the contract law? Kindly pick up our compilation of judgments, Mura.
Yes, which one?
The thick compilation of judgment that we had given. Mura.
Serial number?
This is what is Vitol is serial number. Murad 19.
Vitol.
This is Murad, a judgment of the Honorable Bombay High Court. Running page should be 505 in your Lordship's compilation.
Ghatia.
Kindly come, Lord, to paragraphs 14 onwards in this judgment, which your Lordships would find at 508. My Lord, 508 has a couple of paragraphs. I invite your Lordship's attention to paragraphs 14 and 15.
Yes.
Particularly 15. Your Lordships would find clause 25.1. Of the contract between the parties, my Lord, is set out. Page 508, my Lord.
You are referring to which?
I am referring to the case judgment compilation that we have filed.
This.
But at 505,
This one, Ashok Pandey.
Mora.
Is the judgment is titled as Ashok Pandey versus.
No, it's Vitol SA. Vitol SA versus Bhatia International.
Okay, I think
This volume has a different pagation.
Oh, I'm so sorry.
So here in this volume is 505 something.
Is only kindly just name of the is a Vittel.
Was Vitol, Vitol SA versus
Bhatia International.
Bhatia International. I hope your lordships are looking at our compilation. Mullah.
Yes, yes. Give the physical copy.
Yes, no. So ready रखिଥାନ୍ତେ ନା ତଳେ
Is it?
Yes.
It's okay.
Answer to reply was 505. May I invite your lordship's attention, my lord, to paragraphs 14 and 15 at 508. my lord. .508. But in paras 14 and 15, the High Court takes note of the agreement between the parties to that particular litigation, which contained 25.1, which said an amendment has to be in writing, and unless in writing, it is not binding on the party. Amendment may be made to this agreement, including the terms by mutual agreement, but shall only become binding by written agreement, signed by each of the parties or upon receipt of duly authorized notice in writings to that effect to each party from the other.
But this some agreement, some section of the agreement is quoted here.
That's right, 25.1, which says, Lord,
that is something different in some other context. Why?
No, Lord, with utmost respect, the same context. The context is in the face of 25.1.
Different judgment. We don't know about the agreement clause of that particular judgment.
May just submit, Lord.
What is the sequitur you are getting from this?
The sequitur is this, Lord, that the question that the Honorable High Court posed to itself was in the face of 25.1, which provided that an amendment has to be in writing, signed by the parties, and unless it is in writing and signed by the parties, it shall not be binding.
This is very common.
Just bear with me for a moment. I followed the question. The context is that the parties having acted in a certain way, can the principle of equitable estoppel be invoked against clause 25.1 in the face of clause 25.1? 25.1 says it shall only be binding when it is in writing by the parties. The same context, in my respectful submission, arises in the argument made by the apparent before you, although that argument, according to me, is outside of 34. Please see what the High Court holds. Kindly have para 20. 509.
Yes.
The parties were governed by English law under clause 19 of the agreement.
You're reading para 20?
Para 20, 20.
20. Okay.
The parties were governed by English law under clause 19 of the agreement. Learned Arbitral Tribunal has applied that law. That is the law of equitable estoppel upon the request by BIL for securing the amount under the washout charges pending the negotiations for a new contract. Learned Arbitral Tribunal has considered the law which allows a party to orally or impliedly modify a contract that would be upon the act of the parties. The act of BIL requesting to secure the amount was taken to be an act by which it was bound not under the contract between the parties, but under the principle of equitable estoppel between the parties, under which BIL would be stopped from contending contrary to its request and representation that Vitol may keep the washout amounts as security and not pay to BIL on the due dates. Now, please see 21. It is seen that, in fact, such act of the parties would constitute no amendment to the agreement at all. The amendment to the agreement was contemplated. Agreement was not amended. If it had to be amended, it certainly had to be amended in writing. The new price under a new contract could not have been agreed by the parties orally. A new contract was envisaged in the clause amount relating to amendment of the contract. A contemplated amendment is no amendment. And it goes on. But please kindly see how it concludes. No party would be entitled to contend to the contrary. Why, my lord? Because once they have taken a certain course of conduct, the parties would be stopped from contending to the contrary once they agreed to forbear in any manner. 24 on the over the page, my lord. But not that's a well settled issue, my lord. Foreign law as a question of fact and has to be proved as such. Vitol has filed the affidavit of its barrister in England to show principles of English law relating to equitable estoppel. Indeed, the principle of estoppel is a part of common law, being the law of justice, equity, and good conscience under judicial precedents followed in India as well.
Correct.
Absolutely, Lord. So therefore,
no dispute on this.
Absolutely, I'm so deeply obliged. So, Lord, it cannot be that in a section 34, the lordships are told that not the principle of equitable estoppel is alien to Indian Contract Act. Please look at how is it that equity can be invoked? Equity has not been invoked. It is implied. It's your conduct of the contract. It's your conduct that gives rise to an estoppel. It's not as if the tribunal, in looking at the estoppel, is deciding in the context of 28(2). The argument was made that, Lord, unless the tribunal is empowered by the parties to decide in equity, it cannot decide in equity. But the context, Lord, is different of 28(2). 28(2), Lord, is a complete departure from the contract. From any document for that matter. The parties say, you just decide according to your sense of fairness and justice. That is 28(2). Please have 28(2) with me. So, what the argument is completely with utmost respect. Something which is not called for. And not, I would say, my lord, that argument doesn't hold any water at all. 28(2) is, my lord, not a situation here. Can't be a situation here in our case. 28(2), my lord, as the lordships know, my lord, the parties say, tribunal, you're not bound by anything. You're not bound by any rules. Please decide according to your understanding of the facts by the principles of equity and justice. That is not the same thing as invoking as an issue before the arbitral tribunal the principle of estoppel. I invoked it. They denied it. It was an issue. The parties went into trial on that issue, and the tribunal concludes it. That's not a decision under 28(2), my lord. It could well be a decision of a domestic tribunal. That contracting party, having so acted, is stopped from contending otherwise. It's a long-standing principle, but has no room within 28(2) because that's 28(2) is a different context. Chalk and cheese, if I may say so, my lord. So therefore, the argument that is sought to be made before lordships, my lord, that by invoking the principle of equitable estoppel, the tribunal has acted under 28(2) without the parties empowering the tribunal to so act. That most respect not is a wrong argument. Now, my lord. Yes. Also, my lord, in the same compilation, your lordships would have another judgment. It is called John Distilleries Private Limited. Page 603. John Distilleries Private Limited. In a lighter vein, my lord, please don't go by the name of the parties. My lord, with that kind of a name, my lord, and the conduct, several rules of estoppel would follow, my lord. But not please see at 603, judgment again, my lord, of the Honorable Bombay High Court in John Distilleries versus Brihan Maharashtra Sugar Syndicate.
You are referring to any particular paragraph?
No, it's paragraphs 4 and 5, my lord.
Yes.
In fact, 3, 4, and 5. May I read from para 3, my lord? Lieutenant Counsel for the petitioner submits that the manufacturing agreement between the parties could not have been amended orally in view of clause 32 thereof, which provided for change or alteration of any term of the agreement only if both parties to the agreement consented to such change or alteration in writing. Then counsel submits that it was accordingly not open to the parties to amend or alter the original agreement by any oral agreement, and even if such oral agreement was made, the same would be void. Then counsel submits that in spite of this ground being specifically raised in the written argument submitted by the petitioner, learned arbitrator did not consider this aspect and erroneously decided the matter on the basis that the oral agreement had the effect of modifying the written agreement between the parties. Learned counsel submits that the arbitrator's finding in his behalf is contrary to the express terms of the contract between the parties and thus contains a patent illegality. Learned counsel relies on the judgment of the Supreme Court in Rock Advertising in support of his submissions. Counsel secondly submits that the arbitrator's finding is based on no evidence. Then it goes on to, my lord, deal with certain factual aspects. Please turn over the page, my lord, to para 4. Then an arbitrator inter alia came to a finding that the oral agreement between the parties in the meeting held at Hotel La Meridian, Pune, on 29th of July 2008 between senior executives of the parties, including the chairman of the petitioner, was proved by oral and documentary evidence led by the parties. The arbitrator held that the respondent's witness had deposed to this meeting, which was personally attended by him along with others. The learned arbitrator believed in his testimony and held that in the meeting, the petitioner had agreed to a revision of bottling charges. Learned arbitrator observed that the petitioner, for its part, did not examine its chairman or its director, both of whom were present in the meeting held on 29 July 2008, and that in the premises, an adverse inference could be drawn against it. The arbitrator also observed that the testimony of the petitioner witness showed from first so-and-so, but it goes on to not on the factual aspects. Please kindly have the last sentence. Learned arbitrator in the premises held that there was a consensus between the parties insofar as revision of the bottling charges were concerned. Learned arbitrator's view in this behalf is clearly a possible view, which is supported by evidence. It does not suggest a finding based on no evidence. As long as there is some evidence to sustain a finding, the challenge court under section 34 of the Act does not interfere with the award. Sufficiency of evidence is something for the arbitral forum alone to rule on. A domestic award, section 34 situation, the court says we can't go into it. So not clearly, 28.2 is not even remotely invited in the facts of our case. And it is brought with utmost respect, not wrongly invoked, just to create plot an impression as if something egregiously wrong has happened. And what is also of significance.
You think this principle is laid down by the Bombay High Court is just opposite what has been held in the Rock Advertisement Limited?
No, Lord. Rock Advertising also says that the principle of equitable estoppel would follow. Rock Advertising says, but for that the tribunal must have some written exchange between the parties. Rock Advertising doesn't say that.
No, that is what I'm telling you. Here in this case also you see, on the enhanced rate of bottling and charges, they raised the bills. And those bills were taken into cognizance by the arbitrator.
And I'm so deeply obliged. And in our case, in the case that Lordships are adjudicating, There are minutes of meeting. There are exchanges, communications between the parties. There is a CERC judgment where the benefit was taken of the delays. So what the principle, the question that arises, what is a more fundamental one as apparent raises. And although it is outside of 34, but let's face it. The question is whether at all principle of estoppel applies to a contract which contains no oral modification clause.
Yes.
Which contains no oral modification clause. There is no law whether Indian or foreign.
Submission is too prompt. One is on the premises that universally this estoppel will not apply in arbitration proceeding. Arbitration can get a call on this thing. Another, this is that even if it is we just assume that the estoppel is there. They say the ground of estoppel was raised on the 2010 series, not on 2012 series, but the arbitrator came to a conclusion on the basis of the 2012 series.
But I have answered that on the last
No,
day.
you
That's
have
right.
answered
That's
that.
right. That's right. That plot, both aspects, 2010 and 2012 were pleaded, were in evidence, were at trial before the tribunal, and the tribunal comes to a conclusion.
Okay.
Now the conclusion could be right, conclusion could be wrong.
No,
Conclusion could even.
that you have noted.
That's right. But also have with me 28.3 for a moment.
Yes.
I want to, not really, if I may say so, not invite Lordship's attention to 28.3 to say the tribunal, why the tribunal is not bound by the four corners of the agreement. It can even not go by the usages. Please see 28.3, my lord. A conscious departure by the legislature.
Yes.
Please have the language of 28.3 prior to amendment. I hope Lordship's, the Bear Act gives both. At the footnote, Lordship's would find a pre-amended situation. If not, I can pass on my copy.
It's all right. So we are having it.
Yes, Lord. Please see, my lord. Earlier, unamended 3 said, in all cases, the tribunal shall decide in accordance with the terms of the contract and shall take into account the usages of the trade applicable to the transaction. Now, my lord, please see how it has been amended.
Yes.
So, what shall decide in accordance with the terms of the contract is now given away. While deciding and making an award, the tribunal shall in all cases take into account, not decide in terms,
Yes.
take into account the terms of the contract and trade usages applicable to the transaction. So even, my lord, an arbitration, which is, my lord, a domestic arbitration, the tribunal is not bound by the four corners of the agreement. It has to take those terms of the agreement into consideration. I don't pitch this so high to say when the tribunal can do violence to the agreement. But if the tribunal has evidence before it of a certain kind of conduct by the parties.
This is a very delicate issue that you have raised now.
Yes, Lord.
Because I think a certain amount of dilation is also required on that aspect of the matter.
Please, Lord.
Even if we read very carefully the subsection 3 of section 28, you'll find the words and phrases that they are being used is the terms of the contract and then the trade uses applicable to the transaction. This is the broad two parameters has been deployed in this section.
Please, Lord.
So the terms of the contract is not given a go by because on the basis of
No, Lord.
no, there's going out of these contours of the terms of the contract
Certainly,
for doing an equitable justice.
I don't even mean to say that, Lord. I don't even mean to say that. I'm not pitching my argument so high to say the tribunal can completely walk outside of the contract. No, Lord. But if the tribunal comes to a conclusion based on evidence placed before it of a certain conduct by the parties, which the tribunal finds is giving rise to a conduct which is perhaps not strictly consistent with the terms of the contract, but that's how the parties have acted, the tribunal.
Suppose I'm giving you the hypothetical illustration to
Please,
you.
Lord.
Suppose certain discussion is going on, nowhere recorded. What is the kind of a discussion? Minutes are not prepared. Someone takes by way of the oral evidence proves that kind of that was discussed. And that is completely against the terms of the contract. Contract says whatever will be the decision, which will be the in deviation of the terms of the contract will be taken. That should be in writing. Whether then the arbitrator can take into consideration this kind of the oral evidence, maybe it was sufficiently proved according to the standard. Can it be taken? That is the issue.
With utmost respect, that it can be taken. And that's the departure from the earlier 28.
That is why I'm taking a
That's
little bit dilation about the issue is
Yes,
required.
I'll certainly not deal with it. When I come to not the submissions on law, I will certainly not take losses through some of the authorities on 28.2 and 28.3. But not please take it that the departure from 28.3, which was earlier saying that shall decide in accordance with the contract.
It is a little bit of a paradigm shift from
That's
the
right.
understanding the
It's
law.
And not, I don't, as I said, I must caution here, not myself. I don't mean to pitch my case so high to say the tribunal, which is a creature of the contract, can give away the contract. No, my lord. But if the tribunal comes across evidence of the conduct of the parties, which is not in the as in the present case, the parties have consciously, knowing the terms of their contract, but not while working the contract, have acted in a certain way, and someone has derived a benefit of that, and someone has acted to its detriment.
Oh, that is your this is the core of your.
I only mean to not say this that.
All right.
And not once, either oral or in writing or both. In my case, it is in writing. It's not my oral assertion that this happened. It is in writing, and it is an appreciation of the written exchange and the conduct in terms of the November 2012 meeting, the CERC order and so on, where the tribunal says, I have evidence before me where both the parties have acted in such a way where you have one person who says, well, give me the notice, who today says, you have not given me the notice. But where were you when you were taking advantage of all these delay events before the CERC?
Mr. Mehta, there is another aspect of the matter.
Please, Lord.
In the 2012 series, that is your basis of claiming that this was waived. The giving notice has been waived, right?
Yes, Lord.
In a way that you have not generally says supported by other thing also. But they have raised another question. They have raised that subsequent of the 2012 notices were issued by you.
Now I come straight to that.
No, that is I'm telling you.
Yes. So I come straight.
So it was not at all the waiver of notice for all during the transaction.
With utmost respect.
If you are if you are from a very this is a in a I think in a very shorter way, if you see that will be there.
Now, Lord. Now let us look at those three notices. Subsequent notices. With utmost respect. But I must keep sounding this caution with utmost respect because it's my duty to do so.
No, obviously.
That not all of this now really is taking us into looking at appreciating or not reappreciating certain questions of facts.
No, we are on the face of it.
That's right.
We are not going into
now,
the text of the notices.
Nevertheless, I'm answering it. Now, those three notices are important. Please kindly come. Yes, the 6 notices, I'm sorry. Kindly come, my lord, to my note.
Yes.
Your Lordships may kindly come to page 12. Page 12 of our note.
Yes.
In fact, 14, sorry. No, I'm sorry, page 14. Not 12, yes, that's right. Para 46 onwards.
Yes.
Malas, have this one? May I invite your Lordship's attention to the page before that, page 13.
Yes.
But it is at the foot of the page, Lordship will find para 44, and above that, a heading. Appellant's contention that the parties continue to send notices even after March 2012. That's a precise aspect that Lordships have put to me. That the tribunal also had before it evidence of certain notices being sent after March 2012. What about that? Now, my lord, please see, we have itemized each of these documents which they said were notices post 2012. Page 13, 1-3.
No, where have you itemized those documents?
At the page, at the foot of page, para 44.
No, it says it is
para 44, page 13.
I mean, this is the same page. I don't know. Give the note, there's a difference, you have made a mess here.
No, no.
Page.
Yes.
Give the notes.
No.
Not this note, the earlier note. What was that? The first note of submissions.
This one.
No. They will not have note here. But we gave the note on the last date. I am inviting your attention to that note.
Sorry. No. Part 1. That one.
But I was, in fact, I had read out some parts from that note also.
It has not been scanned, so it is not here.
You are giving from your file. That's mine.
Malas have page 13. But I believe even a soft copy should be available in my lord's records.
More that. Yes, this is
Okay.
I've written this.
Okay, yes.
I've used it in note here this side.
Now, yes, we got it.
I'm so deeply obliged. I believe that even a soft copy should be on my lord's record, not be on the last date.
That is why you are requesting actually.
Yes, Lord. Now, 44. Appellant has alleged that the parties continue to send notices even after March 2012. Appellant relies on the following instances. But there are 6 instances relied upon by them. Now, let's call them out for what they are. Because according to me, this is again, my lord, an argument which is factually inaccurate. Now, please turn the page over and allow me to not take your lordship through these notices. Don't worry. Don't worry.
Yes.
Yes.
But may kindly see, my lord, para 46.
Yes, yes.
This is what SEPCO's letter dated 19th of December 2013 under clause 6.1.4.2. The context of the letter has been given by the award. The letter was merely to inform GKEL that the reliability test run and performance guarantee test of Unit 1 was complete, and therefore SEPCO requested to make payments for the same. Please have this, but there was a compilation that not the appellant handed over of these notices. Please pick that up, Lord. Kindly have that also. We have extra copies in case your Lord want us to tender.
Yes.
We can. Now, let's look at these notices for what they are. Just kindly have it. So this is not something that the appellant had tendered. We are not re-tendering them for convenience. So please have page 1. This is what we refer to in para 46.
Yes.
This is not dated 19th of December 2013. Dear Mr. So-and-so, this has reference to you the situation of execution of works for 4 into 350 megawatt. The reliability run test of Unit 1 was completed on 9th of May 2013 and has been certified by the joint protocol, and completion of the reliability run test of Unit 1 dated so-and-so. Thereafter, SEPCO notified GKL that Unit 1 has been ready and capable of successfully conducting the performance guarantee test, and SEPCO would start the performance guarantee test on so-and-so by the letter dated so-and-so. GKL has not fed back in respect of conducting the performance guarantee test of Unit 1, and the test has not been conducted till now due to reasons such as grid clearance and qualified designed coal which are attributable to GKL. Hence, in accordance with 6.1.4.2, the portion of the contract price due upon performance guarantee test of such unit shall be paid to the contractor. GKL is requested to kindly pay the following amount due upon the performance guarantee test of Unit 1, that is so and so. Lord, this is not a notice. This is not a notice of the kind that the tribunal was dealing with when testing, my lord, the arguments of waiver. It is being wrongly fitted into, my lord, that argument by the appellant. This is to say a certain event has occurred which allows us to claim so much of money from you. Please pay us that money. Unlike saying you are responsible for delay, I am notifying you that you are responsible for 15 days delay. I am notifying you that you are responsible for 20 days delay. I am notifying you that on account of your delay, I have incurred X amount of costs. Those are the notices that the tribunal is considering with respect to not waiver estoppel. Not these.
Just in this last.
And not, it's not.
Just come to the last paragraph.
Yes, my lord.
The word that is coming of the variation order covering the expenses incurred by SEPCO due to suspension and appropriate adjustment to the project schedule.
Yes, ma'am.
So what is the variation order?
Now, my lord, variation, when any contract takes place.
No, I am asking you simply what the variation order is all about.
Not variation order is when there is either in quantity or
in price.
Or in price. Whenever there is a variation is order is issued formally to keep plot that on that basis the price or the quantity
in the principal agreement that is available.
That's right, Lord.
Okay. That is the clarification I want.
That's right, Lord. Yes. Now, my lord, this is with utmost respect, not the context of those notices was prolongation costs, delay related claims. That was the context. But if we read any document out of context, it would not make any sense at all.
No, that is why I wanted to know.
That's right.
Because we have not read the entire principal contract yet. That will come.
So, Lord, the context of these notices has nothing to do with that principle, with that issue. That was brought issue.
I have a little doubt that whether there is any clause regarding the suspension of work and its consequences in the principal agreement.
I'm sorry, not yes.
Whether there is any clause covering the suspension of the work and its causal effects on the price, you call it as a variation order.
So there are clauses in the contract that I can take you to.
Yes.
Which deal with and in what circumstances can the work be suspended.
Yes.
I had indeed given, Lordship remembers, in March of,
right.
I had given a notice of suspension. I did not act on it. And Lordships have seen that part of the award. But if I may just bring Lordships to am I missing something in Lordships' question, or Lordships may just put it to me, but to answer the question, Lord, it is not as if the tribunal, what was placed before the tribunal, what was argued before the tribunal has not considered. The tribunal has considered it, has come to a conclusion. And in respect of this particular communication, now see what the tribunal holds. Kindly come to Lord 755.9 at page 1682. Volume 3, my lord. And all of this plot is construction.
Go to the volume 3.
And all of this plot is construction of the contract, appreciation of evidence, and at the worst, perversity. But that is not the test for an international commercial arbitration award. I'm not saying it is perverse. According to me, it's perfectly justified. It's perfectly legal. It's perfectly reasoned. But even if it were to not be reasoned perfectly, not even then it's not within 34. The fact that I may feel otherwise is not the test.
Do you find any difference between a reasoning drawn without any evidence and with some evidence?
But that, of course, there'll be difference, a world of difference between the two.
Exactly so.
That's right. That's right, Lord. And a reasoning with some evidence is something, Lord, that passes muster. But a reasoning without evidence would not pass muster. No doubt about it. But again, Lord, please look at the context of the provisions.
No, that is obvious.
34(2)(a) would
Yes.
bring it in within the patent illegality aspect, Lord, which is not applicable to an international commercial arbitration. I'm not running away from answering the question.
No, it's all right.
Nor is one not looking at the facts. But now please see, Lord, what the tribunal says in Lord 755.9.
At page?
Lord, that will be page 1682, volume 3.
Your paragraph is? Your paragraph is?
755.9. So you won't find 755 there. Your Lordship would find 9. These are all parts of 755.
No, I understand that. Okay.
May I read Lord subpara 9?
Yes. It starts with the UTC and
That's
the
right,
PGT.
UCT. UCT and PGT for Unit 1 were not undertaken. On 19th December 2013, the claimant wrote asking for payment of 5% of the contract price on the basis that it had been denied permission to undertake Unit 1 PGT due to reasons such as lack of synchronization approval and appropriate coal which are attributable to GKEL. The respondent's response to 21st December 2013 was that the RRT for Unit 1 was not successful and SEPCO has not become eligible to conduct performance guarantee test. Now, that is the context of this notice. That is the context. Not kindly consider this aspect. It is nobody's case that the correspondence between the parties with respect to the work to be undertaken by one or the other ceased after 2012. It's no one's case that the correspondence between the parties also came to a knot, came to a cipher. No correspondence from 2012. No, Lord. Correspondence went on. The question of waiver arose in the context of delays, prolongation costs, and so on under issue 2. That was the correspondence such that the parties insisted, that is GKEL insisted, and SEPCO followed notification of GKEL's delay, of SEPCO's cost prolongation, extra costs incurred, or did the parties give a go-by to that kind of communication? Not the communication per se, not all communications per se, but that kind of communication. This is what losses find in 19th of December letter is a communication with respect to certain tests having been conducted and certain monies that have become due payable under the contract. This has nothing to do with prolongation costs, extent of delay. That you GKEL are in delay of so many days, and I'm notifying you that I will claim the costs of this particular delay from you. Those are the notices, which are the context of waiver argument, not this. Now, please see, the second notice, the second document. Please have this handout. This document is spoken of in para 47 of our note. The second document, page 2. Please see this document, Milord. It is GMR Kamalinga Energy's letter, dated 4th of April 2013. The subject is 4th Amendment of Agreement for Transfer Tower number 2 to Civil Work and Engineering Erection. Dear sir, this has reference to the aforesaid agreement, your proposal, and subsequent discussion. The civil contractor and the owner wish to amend, modify, and supplement the agreement as herein set forth. Then when it contains amendments up to clause 6. And it says, except the above, all other terms and conditions of the agreement shall remain unchanged. But how is this a notice? By one party or to the other? I ask myself. Does it even remotely answer the argument in the context of waiver and estoppel? I can understand. Let's take what
you are just making this statement that this cannot be treated as the notice.
But it is not.
Just try
With utmost respect.
We want to understand that.
Yes, bro. Which is why I'm showing you my loss,
to constitute a notice.
Yes,
they have
bro.
categorically stated what they want for the change in the agreement.
That's right.
They're just making it known to you. What other required to call it a notice?
No, I'm sorry. I'm sorry.
You said that it cannot be treated as the notice.
No, may I just say this? No,
What
when I say
other ingredients should it contain so that you call it notice?
I must confess that perhaps I was not very coherent or clear when I said notice. I must say, I must clarify. When I say notice, I don't mean notifying one from one party to the other. When I say notice, notice in the context of issue 2. Notice in the context of issue 2. But I said so. The communications between the parties did not cease. The exchanges did not cease. The context was issue number 2.
That kind of the 2000.
That's right. The parties said we will not write to each other with respect to you are at delay. No, I'm not at delay. You are at delay. This much is due. No, that much is not due. This much is due. We will cease that kind of correspondence. Not all correspondence, plot. Please don't mistake the word notice as I say it, not to mean notice of any or all kinds, but notice of the kind that is relevant, material, and not that was related to issue number 2. That is the delay related damages. Delay related claims.
So that is where we come down now. That notice means on the notice relating to issue number 2.
Yes. Sorry, what? I'm sorry, I didn't.
So according to you, the notice in this context would mean notice relating to issue number 2.
I'm so deeply obliged.
Yes.
I'm so deeply obliged. And that is the entirety of the context of the award, my lord. The tribunal also goes ahead and says, wherever notices were absolutely a must. But please note that the award is not that without giving notice in any situation, the claimant could make a claim. Now, I'm going to show to you, Lordship, not the award which says, no, this is not the situation of issue 2 kind. In this situation, notice was required and my claims have been rejected. So notice is not of every kind. The tribunal has not concluded that no notification of any claim was required from one party to the other.
Always.
But notices of certain kind were waived by the parties. Notices of other kinds were not waived by the parties. And wherever the notices were not waived, the tribunal has not equal-handedly not found in favor or against the parties.
Always.
This is not a letter that speaks of delay-related claims or damages. Please now have please have the third document of 10th of November. Page 7.
Yes.
Now, please see 10th of November 2012. Dear so this is reference to the above cited subject and letters regarding royalty issue during the execution of CEETC work and GKEL project.
Yeah, that is the explains in the notice is the context of the only means noticing relating to the. Yes.
Well, may I continue? May I continue? Ma?
Yes, yes.
I was showing page 7. SEPCO as one experienced and responsible EPC contractor will implement. It's not very clear. What do you mean? Huh? Yeah. No, but I don't have 7A. I do not have 7A, but can I use your copy? But I'm sorry, we did not get 7A from my friends. So we just passed on the copy that we got. But in my
But we got is 7, we got it.
I'm so deeply obliged.
Yeah.
SEPCO indicated the title of the site materials is in scope of GKEL, and GKEL shall be solely liable for all the responsibility thereon, including the royalty, certainly. Therefore, GKEL shall be solely responsible for depositing and paying relating amount assessed on the same day, on the same any statutory authority, and SEPCO will support and coordinate to provide corresponding measurements and documents as required. This is not the notice of the kind that is not relatable to issue number 2, which the parties have agreed to not give each other. The parties agreed that we will not issue each other one certain kind of notices, and that alone the tribunal takes into consideration for estoppel. Tribunal has not extended no notice to situations like this, and both ways, my claims have failed and their claims have been allowed. I'll show that to my lords from the award. The context is important, Lord. The party said that we will not write each other this kind of notices, where we are saying you are responsible for delay. No, I am responsible for delay.
Got it. This point is very much.
Then what can you see, my lord, 25th of June, page 8, my lord. Sorry. Page 8.
Yeah.
SEPCO has performed and executed the project consisting of 4 units, not only Unit 1, Unit 2 and Unit 3. Payment due to SEPCO but delayed by GKEL has amounted to about so much in accordance with the contract. Current status of outstanding payment of the project is as follows. Then what that is set out. SEPCO has accordingly delayed massive payment due to subcontractors, including suppliers, due to SEPCO's funds shortage resulting from GKEL delayed payment of such a big amount. As a result, the spare parts of Unit 3 cannot be supplied and delivered in time by the sub-suppliers. The required site services representatives of sub-suppliers cannot either be deputed to work on the site, and the Chinese construction subcontractors refuse to depute workmen to the site. Even some of them are planning to evacuate from the site. Moreover, it goes on, my lord. This is not demand for money. Yes. Over the page, my lord, kindly see. I can take losses of the entire document. Please go over the page, my lord. In consideration of the current situation, in order to maintain the work on the site and push forward the project in favor of GKEL, avoiding affecting the project due to so and so, SEPCO requests GKEL to pay off the overdue amount to SEPCO at the earliest. This is a notice of demand for money, which according to us was outstanding. This is not the context of issue 2 at all. Any communication not seen out of context may be misleading, my lord, with utmost respect in terms of impression that it may create. Now, please see, my lord, page 11, number 5, document number 5. GMR writes a letter. This has reference to the reliability run conducted pursuant to clause number so and so, and joint protocol signed by both the parties. We would like to highlight clause 13C and part B so and so. Then it sets out the clause. Though plant could operate for the entire period, annexure A of the protocol specifies some of the limitation plant had during this run. That is so and so. Then they set out about 7 points. In view of the above, it is confirmed that Unit 1 could not be run within the design parameters as agreed under the agreement, without satisfactory working of the systems like so and so, so and so. GKEL shall not be able to demonstrate the performance of unit number 1 to its power procurers as required under its PPAs. It may be noted that till all the above discrepancies are rectified, reliability run of unit 1 shall not be declared to be successful. You are therefore requested to improve upon the deviation shortfall outline. Perfectly valid notice. but of a different kind. The tribunal's reasoning or conclusion is not that the parties had undertaken to not issue any notices to each other, but only with respect to delay-related events. Please have the last document, page 12. GMR's letter, my lord. GKEL here intimates SEPCO that the completion schedule for O&M building is not submitted till date. Moreover, the work progress is very slow. This reflects failure of SEPCO to complete zone. So in this regard, we would like to bring to a notice that clause 7.5 of the contract gives GKEL right to step in to complete the job at the cost and risk of the contractor. GKEL management decided to complete the balance work and debit the cost. This is not after the parties had already not deferred and they had not disputes December 2030. Yeah. And not in this is brought, we have dealt with it in our note starting from paragraph 46 to 51. The last two of the documents at 11 and 12 have been dealt with by the tribunal, my lord. In the note, however, if I may just say, my lord, there is one typographical error in our page reference. In para 50 of our note, instead of 1160, third line, para 50, third line, it should be not 1660, not 1160, 1660.
You are referring to page?
Not in the note. Your lordships would find in the third line of para 50, we have given a page reference of the award, where the award deals with this particular communication. That is not 1160, it is 1660.
This one. What was? 160. Okay.
Okay. Now, my lord, to be able to not clarify the position as to the completely not different context of what the documents your lordships have just seen, the 6 documents that lordships have seen versus what the tribunal was dealing with, please come back, my lord. I think it is important, my lord, for me to re-emphasize that point from the award itself. Please kindly come back to 1527. One 1527, volume 3. It's there. What losses have you? 1527. Got it.
Yes.
Absolutely obliged. Please kindly come to para 165. The issue raises 9 agreed site handover sub-issues. Was there any delay in handover of the land and or issues with access that impacted SEPCO's works? Was the boundary wall intended to provide site security? Did GKEL fail to construct the boundary wall in accordance with its obligations? Did SEPCO fail to discharge its site security obligations? Did the villager disturbances cause any delays? Did GKEL grant SEPCO use of and access to the site to carry out the works in accordance with its obligations? Who was responsible for obtaining the blasting permit? If GKEL did it discharge its obligation? Was SEPCO's work delayed as a result of the above? Is SEPCO entitled to an adjustment in the contract price and or damages as a result of the above? The claimant claims that the critical path of the works for the project was delayed and costs incurred due to respondent's failure to provide uninterrupted site access and build the boundary wall in a timely manner. Respondent disputes that it was responsible for any delay caused. So the claims and counterclaims in relation to delay is the context of the inquiry that the tribunal undertakes on pleadings and evidence by the parties with respect to waiver and estoppel. Not, my lord, demand for money, not breach of warranty, not failure of a test, not to make up the shortcomings in a test, not to rectify any damage caused. Those were, my lord, something that one had to notify. And the tribunal holds that. But says in the context of delay related events, the parties had agreed to not notify each other because this will be very frequent notices.
Okay.
So, my lord, when it comes to the conclusion of estoppel and waiver, it is in the context of delay related. I reiterate, my lord, the tribunal's conclusion is not, and nor was the case of the parties, including of the claimant, that was my client, before the tribunal, that notices of all and every kind have been, my lord, given a go by the parties. Sorry?
Right. Now you can move on.
Yes, my lord. Now, my lord, let me show you as to how, in situations where the tribunal says, well, this is not an issue 2 situation. This is not a delay related situation. The tribunal says, Mr. Claimant, where is the notice? And if there is no notice, out you go with your claim. In respect to the respondent, it says, this is an issue 2 situation, no notice. Your claim is good. Now, please have, my lord. So, therefore, now I come to the next argument that is made, that the tribunal has very selectively, my lord, according to them, once again, outside of 34 argument, but very selectively applied the principle of waiver to the benefit of the claimant and to the detriment of the respondent. In other words, it has not been even-handed. No, nothing with utmost respect.
That is the allegation.
I'm sorry.
That is the allegation. You have to answer.
That's right. I'm sorry. That's what I'm saying. That's the argument made precisely. But I'm so deeply obliged that the tribunal has not been even-handed, and therefore tribunal has given the benefit of waiver selectively to the claimant, but denied it to the respondent. The question is, my lord, some parts of the award are shown to your lordships, my lord. Some parts are not shown to my lords. And unless your lordships read the award in its entirety, my lord, whether it is my friend's presentation to your lordships, my lord, or my presentation to your lordships, my lord, it will remain one-sided. So now let me show you the other part. That's why I'm not, your lordships, here to both the sides, to have the benefit of the other side's, my lord, point of view. Now, my lord, please see, come back to my notice. I itemize claims where the tribunal comes to a conclusion that notice was a condition precedent, not given, the claim must fail. Please come back to my note. Yeah. Now, my lord, please kindly come to paragraph 42 at page 12. At the foot of page 12, losses a paragraph 42, my lord. Please go over the page, my lord. Now, my lord, please see where the tribunal says the claim made by the claimant was not in the context of issue 2 and a notice was required, and want of a notice, the claim fails. Please kindly come to para 308 of the award at page 1565.
02, yes.
Page 1565.
Yes.
Because I believe this Talapatra doesn't have page 1565. Court must is.
Yes.
I'm deeply obliged to this. This was a claim that the claimant made with respect to what costs incurred for change in design of 400 kV switch yard, and claimant had not notified the respondent of this claim. Now, surely on the face of it, this is not a claim with respect to delay prolongation. Please see what the tribunal says from 308. The first change is not pressed by the claimant. I'm sorry? That's right. The first change is not pressed by the claimant. The experts agreed that the impact of this change was minor, should be accommodated. The second change is a financial claim for a variation that was not compromised by the Jinan agreement and needs to be considered by the tribunal. The design of the 400 kV switch yard was changed to reduce the 4-line base to 2-line base so that the power evacuation of the grid would be through 2 and not as originally designed through 4 transmission lines. This meant that changes had to be made to equipment to accommodate the greater amount of current flowing through each transmission line. Higher capacity equipment and cables had to be utilized. The second change required a major redesign and a change to the procurement requirements. Section 4.2.13 and 7.3.13 impose the contractual requirement to give notice that will be or has been an increase in costs or a delay in the achievement of any milestone, respectively by reason of a variation order. Each of those provisions, as discussed above, is a condition precedent. The respondent submits that no notice of variation has been served, which prevents SEPCO now bringing the claim. 312. No proper notice of this claim was given. As the condition precedent has not been satisfied, the tribunal finds that the claimant is not entitled to maintain this claim. A variation order requires a notice. Not given, the claim fails. So notice of a certain kind waived. Notice of other kinds not waived. Now please have 344. Para 344 at page 1573. Your Honor, 344. This is not a claim with respect to change in law that I made. The November 2012 Jinan meeting compromised all claims for delay arising out of events before the meeting, regardless of when the delay occurred. November 2012 Jinan meeting went beyond merely considering the delay which occurred before the meeting, but included the likely delay which was expected to occur after the meeting due to matters arising before the meeting, because they were looking to review and set revised milestone dates that would be achieved in the circumstances then known to exist to both parties. The respondent, in its statement of defense, relied on the fact that the claimant had failed to make an application in accordance with the provisions of the amended EPC agreement. As noted above, the contractual requirement to give notice of this claim is a condition precedent. No proper notice of this claim was given, and there has been no waiver of the obligation to give notice. The respondent is not stopped from enforcing the obligation to give good notice in relation to claims arising in 2009 and 10. These are not pre-2012 events of waiver. As the condition precedent has not been established, the tribunal finds that the claimant is not entitled to maintain this claim. So wherever it felt that the waiver is not applicable in the sense that this is a different situation, either in terms of subject matter or different situation in terms of time. Because waiver is concluded with respect to the 2012 series. So 2010 and 9 events are before the parties decided to waive. And then it was condition precedent. I should have issued notice, my claim fails. Now, my lord, please see the other side of the coin, where the respondent doesn't issue notice and the claim succeeds. Because it is a issue 2 situation. Please now come back to para 43 of my note, page 13.
Para 43, page 13.
Now, my lord, please come to page 1877, volume 4.
Volume 4. One 1877 or 47?
Not 1527. Sorry, 28. Para 1527 at page 1877. 1877. Volume 4, my lord. You give me the PDF page. No, within volume 4. What is the PDF page? Missing that. But PDF should be 44 or 45 of that volume. Okay. Number PC, the tribunal is satisfied that the defects exist. The evidence that the defect was orally notified within the warranty period and with reasonable details. Claimant acted on the oral notification and inspected the work involved in the defect. The defect was also the subject matter of written notifications in accordance with the contractual requirement in the RRT report, which says the deficiency as passing so and so, which also confirms the existence of the defects. It was also notified again on 9th August 2014 as one of the list of pending activities, passing so and so. But tribunal grants at 1529, even when it was orally notified. Likewise, Lord, paragraphs, Lord, I just kindly come back to para 43. I have itemized, Lord, the various claims that came to be granted without notice. Please now come back, my lord, to 1780. Volume 4. 1780. Sorry, that was paragraph 1916. I'm so sorry. I'm so sorry. 1916. Para 1780 at 1916. Now please see, my lord. 1778. Allow me to read from there, my lord. Respondent has rectified this defect by installing additional light fittings in the areas of the power station that have been insufficiently illuminated. Respondent claims an amount of rupees 1.34 crores. 1780. This amount was notified in the joint protocol signed by both parties on 5th June 2014 after completion of RRT of Unit 3. I'll pause here for a moment. So no formal notice. The parties signed a joint protocol and said that yes, this issue remains. No formal notice issued by one to the other. Please go further, my lord. Respondent in response also says that this effect relates to a deviation and or omission from the works. Respondent submits that no notice is required for this defect as the claimant must know what it constructed. My position is set out not in paragraphs 1782 and 1783. At 1785, I take the argument that defect was not notified. Para 1785, Lordship said, the defect was not notified. Please see tribunal's analysis. Claimant submits that this defect was not notified. Tribunal is satisfied that the respondent has provided sufficient evidence of notification to establish contractual notification. So even a joint protocol, no formal notice issued. Joint protocol is enough. Evidence of the existence of this defect is relatively thin. Essentially, it is a statement and it goes on, my lord, and awards in 1789 the claim of the respondent. No formal notice given to me. Joint protocol records this. This was a defect. Claim allowed. Likewise, my lord, at 1923, same volume. Para 1824, my lord. Respondent relies upon the joint protocol, not on any notice given to me. In respect of this, my argument is noted in 1827, saying that the claim was not notified. Tribunal's analysis, my lord. The defect existed and the claim was notified. How, my lord? Through the joint protocol, not through a notice. And the claim is granted to the claimant, to the respondent, counter claimant. Without a notice, a formal notice saying that here is the notice. Joint protocol records that this was to be done. That is notice enough. Then please see, my lord, 1932. Page 1932. Paragraphs 1874. Once again, joint protocol. No formal notice. Tribunal says good enough. No notice required. Claim allowed. 68. Now, please kindly see 1942. The respondent says, I notified it through joint protocol. I didn't issue a notice, but joint protocol was enough. I say no notice. Tribunal says doesn't matter. Allows the claim. So even in situations where the respondent had not issued a formal notice, but relied upon communications, correspondence, or joint protocol, the tribunal says good enough. Now, please kindly come back in the note to a very important aspect. And that is, paragraph 35 at page 11. Well, we submit our response to this argument, which is with utmost respect an argument which is misplaced, factually inaccurate, misplaced, and not puts two unknown or not different contexts together to say, well, the tribunal has applied a principle in a one-sided manner and not even-handedly. Argument is, my lord, that their counterclaims amounting to more than 150 crores have been rejected. A broad brush argument. But the claimant's claims have been allowed. I have shown to the tribunal, my lord, from the award. But now I take losses through in some detail with respect to this because two of these claims were highlighted. Now, please turn over the page to para 36. Kindly come to, my lord, page number 1832, volume 3. One 1832. What is it? 1832, brought para 20.1 or issue brought 20.1 and 20.2. Issue 20.1 is SEPCO in breach of its obligations in relation to each of the alleged defects in Exhibit R173 dated 5th September 2018. 20.2, if so, what damages are GKEL entitled to recover for each of the defects that exist in the power station? Now, these are defects claims. Please see, my lord, how the tribunal deals with them. Kindly, my lord, come to paragraph 1295 at 1836. Volume 4, my lord. 1836, volume 4. A defect is defined, page 1836, my lord. A defect is defined, para 1295. In section 1.1 of the amended CWEETC agreement as follows: defect means any error, omission, deficiency, insufficiency, or defect in or to the works, and any damage to the works to the extent that such damage is caused directly or indirectly by any error, omission, deficiency, insufficiency, or defect in or to the works, and includes any latent defect. The respondent submitted a Scott schedule, and it goes on, my lord, to give details of what was the claims that the respondent was making before the tribunal, complaining that SEPCO's works had defects as defined in the contract. Now, my lord, please have para 1319 at page 1841. This issue, my lord, occupies a great length in the award. Kindly come to page 1841, paragraph 1319.
Yes.
Please see, my lord, what was the legal basis as argued by the respondent before the arbitral tribunal in respect of this claim? The respondent submits that the legal basis of R173 claims is straightforward. Each is a defect as it is either a part of the works, which is a deviation from the EPC technical specification or design documentation, or part of the works that has failed, damaged, or is not functioning, or has not met the agreed performance parameters. The respondent replied in particular on the following warranties. Relied in particular on the following warranties in section 10 of the amended CWEETC agreement. Then those warranties are set out at page 1842. Please go further and kindly see about 1322. This is very important. Because again, the appellant seeks to create a misconception that my claims have been denied to me. Look at this arbitral tribunal, how shocking, how stone-hearted this tribunal was for the respondent. That's the argument made. But please see, what is the foundation of their claim? Please see the definition of warranty. The warranty period is defined in section 1 as follows. Warranty period with respect to a particular unit means a period of 12 months from the completion of successful performance guarantee test of such unit, and facilities common to the unit shall mean a period of 12 months from the completion of the successful performance guarantee test of the last unit. So the warranty in respect of a unit is for a certain period. The warranty period is a period of 12 months. Please go further. 1323. Tribunal notes that it is not necessary to consider the respondent submission. We can skip this. 1324. Nevertheless, the tribunal notes that for different reasons, the respondent and claimant agreed that the warranty period expired in June 2015. The respondent accepts that it commenced on the warranty commences on 3rd June 2014, and the respondent must demonstrate that a defect arose before 2nd June 2015. So the agreed date of commencement of warranty is June 2015. Expiry. Expiry of warranty is June 2015. So therefore, the defect must have, in respect of which warranty is invoked, should have not arisen between 2014 and 2015. Now, please see 1325. The respondent said that the claimant submitted that it was not liable for the defects that are not notified within 45 days of the end of the warranty period. The respondent said that the short answer to this point is that it was not pleaded. There was no document production or witness evidence dealing with the issue of notice. It is too late for the claimant to raise this just before the start of the hearing. Notwithstanding and without prejudice to its position that in relation to the notice, the respondent submitted that it had provided the claimant with adequate notice of the defects within the meaning of 10.3 from as early as May 2013 after the RRT of Unit 1. The respondent notified the defects primarily, but not exclusively, by way of 5 documents, which were the 3 joint protocols after completion of the RRTs dated 15th May 2013, 18th November 2013, and 5th June 2014 for Units 1, 2, and 3 respectively, and the UCT and the PGT test reports for Unit 1. The respondent submitted the annexures to each of these 5 documents, set out the various defects that the claimant agreed to rectify, and these defects were then included in the 5th September 2018 version of R173. Additionally, the respondent submitted that it sent various additional notices, such as three letters dated 21st February 2013, 14, 23rd February 2015, and 7th March 2015. The respondent stressed that section 10.3 only requires the respondent to notify the claim about such defects and did not require the respondent to give notice to rectify defects in any particular form. Then it goes on, my lord, to crystallize, my lord, the claim. Kindly turn to para 1337, my lord. 1337. 1845, my lord. Tribunal's analysis. Because I'm past 4 o'clock. I can start.
We'll continue tomorrow then.
I'll continue here tomorrow from 1845.
My lord, my learned friend, are you good for tomorrow or day after? Also?
I'll have to go back second. Yeah. But I'm trying to, but there may be a situation that I may not be able to conclude tomorrow, but I'll try my best. I'm trying to go as fast as possible.
Give a note. If you can't conclude, give in a note, a good note.
No, my lord, I'll have to make some submissions.
We have to extend.
I'm trying to go as fast as possible.
A little time day after tomorrow for a
As
rejoinder.
per our schedule, we are not going to extend any time. If any party can't conclude, they should give in the note. We'll read the note, no problem.
Lord, I can only request, but I bow down. I know the pressures that losses have on your time. I'm trying to conclude.
Your notes are very well explained. So
No, my lord, but we know that losses will not read my lord, every piece of paper that there is, but not we have a certain responsibility, my lord. We need to discharge that. But I'll try, my lord, my best. I'll try my best. It may be that I may need about half an hour. I'm not saying give me 2 more days. It may be that I need just half an hour to 45 minutes extra time. Losses will accommodate me to that extent. I'm not seeking a long rope, my lord. I know losses have given me a long rope of 3 days anyway.
maybe time, maybe half an hour, something we can.
That's it. And that's all. Half an hour, 45 minutes is all I'll need from you. I'll try and conclude as quickly as I can. I'm sorry, what?
Good hour we can extend, not the day.
No. So if losses can sit a little longer tomorrow, I can try and conclude. Deep reply.
I think there will be no rejoinder from the appellant. Sorry. There will be no rejoinder from the appellant, I believe.
We will file notes.
Oh, thanks.
That's it.
Deep reply.